Mr. Sergeant of Arms, invite the members into the chamber and close the doors. I hereby declare the House of Representatives of the 114th General Assembly of the State of Tennessee now in session. Leader Lamberth, you are recognized.
Thank you, Mr. Speaker. After consulting with Representative Doggett, I move to dispense with the calling of the roll.
Without objection, so ordered. Call up next bill, Mr. Clerk.
Mr. Speaker, the House is ready for item 46. Item 46, House Bill 410 by Chairman White, relative to English language learners. Mr. Speaker, Senate bills on the desk.
Chairman White, you're recognized. Representative Wright, for what purpose? I can't even see whose desk. Representative Davis.
Thank you, Mr. Speaker. I know we're out of order, and I hope that y'all will take an indulgence for us to recognize our Knox County Junior Commissioners that are here today. We just want to say thank you, and please make them welcome.
Chairman White, you're recognized.
Thank you, Mr. Speaker. Move to substitute conform to Senate Bill 246.
Chairman White moves substitute conform Senate Bill 246, probably seconded without objection. So ordered. Chairman White.
Thank you, Mr. Speaker. I move passage of Senate Bill 246 on third and final consideration.
Chairman White moves passage of Senate Bill 246 on third and final consideration. By section, Mr. Clerk, call First Amendment.
House Education Committee Amendment number 1.
Vice Chairman Raper, you're recognized.
Thank you, Mr. Speaker. This is not in the Senate bill. Move to adopt and defer to the sponsor for further explanation.
Vice Chairman Raper moves adoption of Committee Amendment number 1, probably seconded. Any discussion on the amendment? Seeing none. All those in favor of adopting Committee Amendment number 1, say aye. Aye. All those opposed, say no. The ayes have it. You adopt next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Chairman White, you're recognized.
Thank you, Mr. Speaker. Members, this simple bill, all we're doing with this is requiring the Department of Education to convene a working group to study and develop best practices, strategies, and programming for our English language learner teachers or educators. As you know, we have a lot of English language learners in our state. It takes special skills. We want to make sure that we're helping our teachers as much as we can to come up with best common practices. And with that, Mr. Speaker, I renew my motion.
Chairman White renews his motion. Any discussion on the bill? Representative Hardaway.
Thank you, Speaker. Just want to err on the side of caution. Chairman, is this what holds state of Tennessee?
Chairman White.
That is correct.
Representative Hardaway.
Thank you. I'm glad you got that in you. So I'm going to be asking you to do some other bills like that. Thank you, sir.
Representative Burkhart, you're recognized.
Thank you, Mr. Speaker. Move approved question.
Previous question been called. Is there objection? Seeing none, we're voting. All those in favor of Senate Bill 246 as amended, vote aye when the bell rings. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, please take the vote.
Ayes 86, no nays, 1 present, not voting.
Senate Bill 246, having received a constitutional majority, I hereby declare passed without objection. Most reconsider table. Next bill, Mr. Clerk.
Mr. Speaker, the House is back to item 29. Item 29, House Bill 1144 by Chairman Boyd, relative to private prisons. Mr. Speaker, Senate bills on the desk.
Chairman Boyd, you're recognized.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 1115.
Chairman Boyd moves substituting form Senate Bill 1115, probably seconded without objection. So ordered. Chairman Boyd.
Thank you, Mr. Speaker. I move passage of Senate Bill 1115 on third and final consideration.
Chairman Boyd moves passage of Senate Bill 1115 on third and final consideration, probably seconded. Mr. Clerk, call the First Amendment.
House State and Local Government Committee Amendment number 1. Mr. Speaker, same as Senate Amendment number 1.
Chairman Crawford, you're recognized. Oh. Vice Chairman Wright, you're recognized.
Thank you, Mr. Speaker. Move to Senate amendment. Same as the Senate amendment number 1. Move to withdraw.
Without objection, amendment number 1 withdrawn. Next amendment, Mr. Clerk.
House State and Local Government Committee Amendment number 2.
Vice Chairman Wright, you're recognized.
Thank you, Mr. Speaker. Move to withdraw.
Without objection, amendment number 2 withdrawn. Next amendment, Mr. Clerk.
House Finance Ways and Means Committee Amendment Number 1 filed as House Amendment 3.
Chairman Hicks, you recognize.
Thank you, Mr. Speaker. Move to adopt, defer to the sponsor for further explanation.
Chairman Hicks moves adoption of Committee Amendment Number 3, probably seconded. Any discussion on the amendment? Seeing none. All those in favor of Committee Amendment Number 3 say aye. Aye. All those opposed say no. The ayes have it. You adopted. Next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Chairman Boyd, you recognize.
Thank you, Mr. Speaker. Members, it is an honor to be standing before you today on this particular piece of legislation, but I'm very sad about the circumstances in which I'm here. My friend Tim Leeper in 2023 lost his son tragically. He was in a private prison in Trousdale County. And so what House Bill 1144 seeks to do is to bring some accountability to the number of inmate deaths and violence that occur in our private prisons in Tennessee. And so what this legislation would do is it would reduce the inmate population in our private prison facilities by 10% if the death rate is double that of an equivalent state-operated facility. It will be based on a report that is released each fiscal year. And so that would be, stand by for just a minute, the department's annual statistical abstract that would be released at the end of June each year. And it has to be done within 90 days of that report coming out. Mr. Speaker, I renew my motion.
Chairman Boyd renews his motion. Any discussion on the bill? Representative McKenzie.
Thank you, Mr. Speaker. And to the sponsor, I don't fall in love with a lot of bills, but this one is needed. Thank you for bringing this piece of legislation. As late as today, I got a email from a constituent whose son is in one of the private prisons. I won't say which one, but just all manner of things. And at some point, there's smoke, and that's what this bill seeks to do: find the smoke, find the fire, and it also holds them accountable with some measurable things in our private prisons. So again, thank you for bringing this much needed and timely piece of legislation.
Chairman Boyd. Very good. Representative Hardaway.
Thank you, Speaker. To the sponsor, when we move that 10%, where will they go? And are there any other penalties for the operator?
Chairman Boyd.
Thank you, Mr. Speaker. So the inmates that are taken out of the private prisons will be placed in the Tennessee Department of Corrections prisons. They'll just be absorbed into those. And so there's no additional penalty because private prisons are compensated by the number of inmates that they have. Just losing 10% of their inmate population would hit them pretty hard financially.
Representative Hardaway.
Thank you. I think they ought to be hit harder, but we can talk about that for next year. So we remove the 10% and they continue to operate the facility. How does it ramp up into additional penalties through reduction in the prison population? And the other part of that is, what role will the Tennessee Department of Corrections play in improving the work of that penalized prison facility? Will they be on the ground, actively engaged?
Chairman Boyd.
Thank you, Mr. Speaker. So, the Department of Corrections will draw down the population by 10%. Department of Corrections does have oversight over that, and I would imagine that they would have people on the ground and that the private prison would want to get the standards back up and rectify the situation as quick as possible. But that would be directly under the oversight of the Tennessee Department of Corrections.
Representative Hardaway.
All right, and the costs involved, even the transfer of the prisoners, additional costs, if there are such, for the additional personnel needed to supervise their former inmates, is that also part of the penalty that's imposed on the private prison operator?
Chairman Boyd.
Thank you, Mr. Speaker. No, the penalty is that they would lose 10% of their inmate population and the financial cost that's associated with that. And so that is the penalty. Representative, the bill is not perfect, but it's a step in the right direction. And anyone here in this body is welcome to come next year and file additional legislation. And we have a long ways to go. But I did work with my friend and constituent who lost a son, and he had some ideas, and we sort of culled those down into this idea. We thought this was the best one moving forward that we could get done this year. And we were able to do it in such a way that there was no fiscal impact to the state of Tennessee. I believe that there will actually be a cost savings if this were to happen, because the revenue that we would not spend at the private prison, but it was enough that it won't cost the state that much money, that it came up as insignificant in the fiscal note as far as reabsorbing those inmates into the Department of Corrections prisons.
Representative Hardaway.
Thank you, and I support your bill. Unfortunately, I've had constituents who have lost their lives, families who have had family members lost their lives, been assaulted, et cetera. It's the biggest mess that you could imagine. So I would like to work with you next year to take this further, because those rascals who are operating those private prisons, who are not doing what they should do to fulfill their contractual obligations, not only to the prisoners, but also to their staff, putting them at risk. They need to have some penalties, and I'll be glad to work with you next year on that. Thank you, Speaker.
Chairman Boyd.
Thank you, Mr. Speaker, and I appreciate your support of the bill. And there's still time to get up here and co-sponsor it if you come up here now.
Representative Pearson.
Thank you, Speaker and sponsor. I believe there needs to be more regulation for private companies that are doing what, in essence, a government function is. I don't believe we should have anything called private prisons, because it doesn't make sense that people would literally make profits off of the incarceration of people in our communities. Here's the challenge that I have with the legislation. And first, forgive me, I'm sorry to your constituent for the loss of their child in a private prison, and appreciate the fact that you all worked on this legislation together immensely. Today in Shelby County at 201 Poplar, our county jail, there are 140 inmates or incarcerated people who are supposed to be under the state's care. Right? The Tennessee Department of Corrections is supposed to have transferred them already, but they haven't. And so I'm worried that if this did take effect, the Tennessee Department of Corrections still would not really absorb them into the system, and they'll still be in a county jail where the county is actually taking on the cost of what the state's supposed to do. So in your conversation with them, and I understand you said there wasn't a fiscal note to the state, is that cost just being passed down to the counties?
Chairman Boyd.
Thank you, Mr. Speaker. Well, if they are put in a county jail, which you're right, that does happen sometimes. Sometimes state inmates are placed in county jails. They are compensated by the state. And my understanding is that usually costs less than what it does to put them in a private prison. But that would be absorbed by the state if the state put them in a county jail.
Representative Pearson.
So just for clarity's sake, they pay less money for those people who are incarcerated to the counties than they otherwise would pay at the state facilities. And so, one, I am supportive of regulating private prisons. Don't think they should exist in the first place. But I also am really cautious that the Tennessee Department of Corrections has not done the best job of caring for the people who are incarcerated and under state care. And that cost is being shifted substantially, in our county at least, to our county for costs that should be covered by the state. And the amount of money that we are getting is not equitable to what it should be otherwise. And so I just wanted to see what you may have learned or gathered from TDOC from that, but appreciate the legislation and appreciate your constituent also bringing it to you to honor their child.
Representative Parkinson.
Thank you, Mr. Speaker. Move previous question.
Previous question may call. Is there objection? Seeing none, we're voting. All those in favor of Senate Bill 1115 as amended, vote aye when the bell rings. Those opposed, vote no. Has everyone voted? Does anyone wish to change their vote? Mr. Clerk, please take the vote.
Ayes 93, no nays.
Senate Bill 1115 having received constitutional majority, hereby declare passed by objection and most reconsider tabled. Leader Lamberth, for what purpose?
Thank you, Mr. Speaker. Move to take up item 3 on today's calendar, SJR number 25.
Without objection, so ordered.
Speaker Sexton, you recognize. Mr. Clerk.
Mr. Speaker, that's item 3, SJR 25, a resolution proposed amendment to Article 1, Section 15 of the Constitution of Tennessee relative to bail.
Mr. Clerk, call up next bill. Speaker Sexton, you recognize.
Thank you, Mr. Speaker. I request the clerk read Senate Joint Resolution 25 for its third and final reading.
Mr. Clerk, you recognize.
Senate Joint Resolution 25 on third and final reading. A resolution to propose an amendment to Article 1, Section 15 of the Constitution of Tennessee relative to bail. Whereas Senate Joint Resolution number 919 of the 113th General Assembly, which proposed amendment of Article 1, Section 15 of the Constitution of Tennessee relative to bail, was considered and agreed to by a majority of all the members elected to each of the two houses, as shown by the yeas and nays entered on their journals. And whereas on April 23rd, 2024, such resolution proposing such amendment was published in compliance with Article 11, Section 3 of the Constitution of Tennessee, now therefore be it resolved by the Senate of the 114th General Assembly of the State of Tennessee, the House of Representatives concurring, that a 2/3 majority of all the members elected to each house concurring, as shown by the yeas and nays entered on their journals, that it is proposed that Article 1, Section 15 of the Constitution of Tennessee be amended by deleting the following: that all prisoners shall be bailable by sufficient sureties unless for capital offenses when the proof is evident. Mr. Speaker, I'll start that paragraph over. That all prisoners shall be bailable by sufficient sureties unless for capital offenses when the proof is evident or the presumption great, and the privilege of the writ of habeas corpus shall not be suspended unless, when in case of rebellion or invasion, the General Assembly shall declare the public safety requires it, and substituting instead the following: A, all prisoners shall be bailable by sufficient sureties unless for the following when the proof is evident or the presumption great. 1, a capital offense. 2, an act of terrorism. 3, second-degree murder. 4, aggravated rape of a child. 5, aggravated rape. 6, grave torture. And 7, any other offense for which, as of November 3rd, 2026, a defendant, if convicted, could not be released prior to the expiration of at least 85% of the entire sentence imposed. B, in any case in which bail for an offense listed in subsection A is granted or denied before conviction, the judge or magistrate shall place in the record the judge's or magistrate's reason for granting or denying bail. C, the privilege of the writ of habeas corpus shall not be suspended unless, when in case of rebellion or invasion, the General Assembly shall declare the public safety requires it. Be it further resolved that in accordance with Article 11, Section 3 of the Constitution of Tennessee, the foregoing proposed amendment shall be submitted to the people at the next general election in which a governor is to be chosen, the same being the 2026 November general election, and the Secretary of State is directed to place such proposed amendment on the ballot for that election. Be it further resolved that the Clerk of the Senate is directed to deliver copies of this resolution to the Secretary of State, with this final resolving clause being deleted from such copies.
Speaker Sexton, you recognize.
Thank you. Thank you, Mr. Speaker. Members, it's an honor to be down here before you today on this constitutional amendment. Let me just say before we get started that every single DA, sheriff, and police chief in our state agrees with this constitutional amendment. Every single one, regardless of party. This is a bipartisan effort for our state. The residents of our state agree with this resolution in a bipartisan effort. The purpose of our judicial system is to protect society, to protect our families, to protect our homes, our streets, our property from violent criminal offenders. Unfortunately, in our state right now, our Constitution is our limiting factor in that regard. Our Constitution says that we can only deny bail for capital offenses. 100 years ago, a capital offense was stealing a horse. Today, it's murder. And we passed a bill here not too long ago about child rape for those younger than the age of 12. That is the only thing that can be denied bail for in our state. This constitutional amendment merely allows judges the discretion. Let me repeat, the discretion. It's in their ability to make that determination on whether or not they should deny bail to the most serious violent crimes in our state for that offender. Working with the DAs, the sheriffs, the victims. This constitutional amendment protects victims. There is hardly anything worse than someone being bailed out who's a violent criminal with a violent past, only to find that they committed another violent crime and we have another victim. There was a 13-year-old child who had a mental health breakdown in our state. That child went to one of our local children's hospitals in our state. They were put under the watch of an employee named Terrence Boyd, 13-year-old child, who ended up raping the girl at the hospital. DNA evidence proved that that individual did it. Guess what could not be denied on that individual? Their right to bail. Not only did they receive bail, it was set at $150,000. It was later reduced to $75,000. In that example, that offender, in my opinion, that judge should have had the capability to deny bail, to protect not only that person, but that victim and other victims, and send a clear message in our state that we will not tolerate violent crime, and that there are certain offenses that are so heinous and so violent, our judge should have the tools in the toolbox to look at each one separately and make that determination. That's merely what this constitutional amendment does. It just merely gives the judges the discretion to deny bail against the most heinous and violent criminals in our state if they chose to do that. And with that, Mr. Speaker, I move to concur in Senate Joint Resolution 25.
Speaker Sexton moves to concur in SJR 25. Any discussion? Representative Scarborough.
Mr. Speaker, I can think of no greater charge we have as a body, and I have great confidence in this body that we understand that we want to keep our citizens of Tennessee safe. Reducing recidivism is the number one thing we can take care of here. I can't think of a better measure right now to give another tool, another option, more discretion to that judge on the cases we have before us here in Tennessee. And I look forward to supporting this bill.
Speaker Sexton.
Thank you.
Representative Hardaway.
Thank you. Let's see. I don't know whether to thank you, Speaker, and then address the Speaker. But I support the bill. I know a lot of folks about to fall out their seats watching this at home. However, there is no greater charge, as my colleague stated earlier, that we have as public servants than the public safety. The fact that the bails are now set for some of these same folks extremely high, and yet it's constitutionally suspect when a judge may mess up and say, that's why I set it high, then you leave it open to challenges. So we certainly need to close that constitutional gap. And if there is enough evidence that you are a danger to the victim or to others in the community, then we need to be able to keep our hands on you physically until your case is adjudicated. This is for the most horrendous, despicable crimes. And I support this SJR, and I urge my colleagues to also support it. And I urge the citizens of this great state of Tennessee to vote for it when it's placed on the ballot. Thank you.
Speaker Sexton.
Thank you, Representative. And let me just say, if the people of Tennessee, because this is what this is, we just merely are doing this to put it on the ballot for a vote and letting the people of Tennessee make the decision for themselves. But if the Tennessee approves of this, we will join 22 other states that have some form of this, like we're trying to do. And I agree with my colleague from Shelby County. Setting high bail to keep people in because you're afraid to let them out should never be done. Do the judges do it because they can't have the capability to deny them the bail? And that's just wrong. And so having this constitutional amendment where the judge has the discretion in their toolbox to deny bail also I hope will solve that issue as well, which will artificially inflate bail, unfortunately. It also sets an even playing field between those of all income levels based on the crime as well, in my view. And then the last thing is, a lot of times what happens too is sometimes people are overcharged to try to increase the bail amount. And so what I'm hopeful in this amendment is that you bring some type of parity across the board. So you don't have to do all these artificial things in order to try to keep somebody in the jail or in the prison and not let them out until their trial. It should be a very clear assessment that the judge can make to determine the risk and the offender on whether or not they should deny bail. And if they don't, then hopefully they will set a bail that would be affordable and reasonable for them. Thank you.
Representative Parkinson.
Thank you, Mr. Speaker number 2 and Mr. Speaker number 1. I want to say that I am honored to support this legislation and to have been one of the initial supporters from the beginning because it just made sense. Too many times we see a push to coddle those individuals that are most destructive to our communities. Too many times we see a push to make excuses for those individuals that are most destructive to our communities. But I can tell you this, my constituency is sick of it. Those individuals that live and work in District 98, they are absolutely sick of it. When you look at the fact that in my district, there was a shootout of some young people because one group was trying to steal the sneakers of another group or of another individual. But the larger group, as they were shooting at the individual that was shooting at them, had a 10-year-old child ducking behind the car with them as they were shooting back. The child care center next door to that place where the shootout happened, 9 parents snatched their kids from that child care center that day. That's $3,000 a week lost to that business owner. 2 employees were released because of the actions of these individuals. The property values in that neighborhood have decreased because of the actions of these individuals. Everybody is paying the price except for the folks that are doing the acting. And my people are sick of it. And I'm sick of it. My daughter, I have a brand new granddaughter who's 7 months old. My daughter told me last weekend, she said, I wanted to take the baby to Tom Lee Park Saturday, but thank God I didn't, because some individuals with hoods on, with ski masks on, came to Tom Lee Park that we made an incredible investment in. The park is incredibly beautiful. And they gunned down a teenager right there in the broad daylight at Tom Lee Park. No one has to live like that. No one has to accept hearing gunshots in their neighborhoods. No one has to accept seeing a 16, 15-year-old laid out in broad daylight, close to 1 p.m., with blood coming from his head in one of our most prestigious parks in Memphis. And I'm sick of it. I live in a decent neighborhood. I hear the gunshots on Saturday evenings. Everybody is sick of it. And it's time that we do something about it. It's time that we stop coddling those individuals that are the most destructive to our communities. And so I am going to be preaching this. I'm going to be pushing this. I'm going to be pushing other legislation that will make it so that people understand that this is unacceptable. Unfortunately, people in a lot of our communities have just grown to accept it. You don't have to accept this. And it is our duty as legislators to ensure the safety of our constituents. I stand with you, Mr. Speaker, and I appreciate the legislation.
Speaker Sexton.
Thank you.
Leader Lambert.
Thank you, Mr. Speaker. And I know this is a constitutional amendment, so it's not a bill. This will take the people of Tennessee voting to implement it. But I can tell you, after practicing law for almost 20 years now, and 7 of that as an assistant district attorney, the rest in private practice, I've seen the revolving door of the criminal justice system just turn dangerous people out over and over and over again throughout this state. And I've gone to some of those judges and I've said, look, how on earth could you set a bond at this amount for this type of person? Just having to ask as a member of the community. And every single time they say, it's because y'all haven't changed the laws. You haven't changed the Constitution to give me the authority as a judge to hold that person incarcerated, innocent till proven guilty. But if somebody has got 30 prior felonies, just as my friend from Shelby County said earlier, if somebody's got 30 prior felonies and they've done it over and over and over, murder, rape, robbery, you name it, and then they get arrested again on another felony, a serious felony, that's one of these that falls under truth in sentencing, why would we not at least hold that person without bond, or at least give the judge the authority to prevent additional carnage? There are people out right now that, while out on bond in this state, committed not 1, not 2, but 3 different felonies while on bond for the first felony. When you do that and you prove to the judge over and over and over again that that's the person that you are, you should be held without bond. We should support this. And I hope the people of Tennessee vote for this in large numbers because, again, I stand with my friend from Shelby County in saying we are all sick of this, because every single person from Mountain City to Memphis is a Tennessean. And every single Tennessean deserves to be able to send their child to school and know that they're going to be safe, deserves to be able to go to the grocery store, the park, to work, and know that they are safe. And that is not true in many of the neighborhoods within our state. And we all should care about. Just because your district may not have a high crime rate doesn't mean you shouldn't care about this bill. Every single one of us should, because every single Tennessean deserves the right to be safe. That's the number one thing. So, Mr. Speaker, thank you. I know you've worked on this for years. It says a lot for you to come down in the well and present it today and take whatever questions that may get fired at you. But just thank you for your leadership on this. I know if Tennessee adopts this, we will be safer afterwards, just like those other 22 states that you mentioned, because they figured it out and we can too. Thank you, Mr. Speaker.
Speaker Sexton.
Thank you.
Representative Pearson.
Thank you, Speaker. A couple questions. Speaker, does this or would this only apply to people who, for instance, have committed 30 prior felonies?
Speaker Sexton.
Thank you, Ms. Speaker. This would apply to individuals who commit certain violent crimes like first-degree murder, second-degree murder, grave torture, aggravated rape of a child, aggravated rape, and so forth.
Representative Pearson.
So a person who is convicted of one of those, say for their first time, without seeing anything that they've done prior, according to this, would be, the judge would have the discretion to give them bail or not. And the reason I'm asking for clarity is because some of the examples that I've heard have been about somebody who's committed a whole lot of crimes, and now the judge needs to have the ability to do something more than they're currently able to do.
Speaker Sexton.
This would give the judge the discretion to evaluate every single offense independently of one another. Whether it's one case that could be one person who committed 6 different crimes and they're so heinous he could do it. It could be a career habitual offender who's committed violent crime. It would be based on those violent crimes committed at that time, whether they've committed 1, 5, or a history of those crimes.
Representative Pearson.
Thank you. Or it could be a first-time offender.
Representative Sexton.
Could be if you committed any of these crimes listed, like second-degree murder, rape of a child, aggravated rape of a child. Yes, those could be so heinous and so offensive that the judge could consider that.
Representative Pearson.
Right. But the people that we're talking about, they haven't yet gone through the judicial system to then learn whether or not they were guilty or not guilty. Is that correct?
Representative Sexton.
We're not changing anything currently in the judicial system. Right now, you can deny bail for capital offenses. And so that would be the process. We're not claiming guilt or innocence in this. That's not what bail is about. There's no bail. There's no denying bail. If you have someone who committed capital offense murder, the judge has that capability to deny bail, whether for whatever reason. This would just expand the list of heinous violent crimes.
Representative Pearson.
Thank you. One of the reasons I'm asking that is because in the articulation of the arguments that I've heard from all of my colleagues just about thus far has been, these are cases where somebody has committed several crimes and the court now needs the ability to do this. I think in the example that you used, there was DNA evidence is the reason that judges need the ability to do this. And if it's DNA evidence, that being admitted obviously is going to help the prosecutor. But the question that I had, which you answered initially, was that someone who has not gone through the judicial process to learn whether or not they are guilty or not guilty, this is then being used as a determination, as far as I can determine, of guilt or innocence, or whether somebody's guilty or not guilty. And even in the explanations that people are giving here, we are already deciding who should be in jail and who should not be in jail, as if our criminal legal system is perfect, as if our criminal legal system always gets this right. As if there aren't people right now in 201 Poplar, in our counties and in our communities who right now have been denied bail and are unable to live their lives. And when they go to court, if they go to court, when they see their court date, it can be found that they were not guilty. So taking somebody's liberty is not a small thing. And I disagree with the founders a whole lot. But the idea is to take somebody's freedom, to take somebody's ability to move, to be in community, to raise their families. That means there must be an extraordinarily high bar set. And what is concerning to me about this language that judges are going to get discretion, judges are imperfect people with their own biases as well that they bring into the courtroom. And there can, again, be a disproportionate harm on poor folks, a disproportionate harm on black folks, on Latino folks. There can be a disproportionate harm. And so, yes, the crimes are heinous that you have articulated in this constitutional amendment. But when we talk about safety and protecting people, we also have to protect the people who are being sentenced who have not committed the crime for which they are being accused. We have to think about that as well.
Speaker Sexton.
Yeah, you and I just have a different opinion on how to keep violent criminals off the street, and that's fine. Look, at the end of the day, most of the serious crimes that could have been avoided if the judges simply had the discretion to deny bail. That's a fact. That's a fact. In the U.S., it's right here. In the U.S., at least 12% of all crimes are done by repeat offenders. 12%. So when you're sitting here and you're looking at things to do or not to do, in that case that we mentioned of the 13-year-old, the person wasn't charged until the DNA evidence came back. You failed to mention that point. They weren't charged until they had the DNA to say that they acted in it. They weren't charged prior to that. But once again, that person who did that offense, and I don't care if it was the first time offense or their fifth offense, it's atrocious either way you look at it in my book. It's atrocious. And I wish you could stand there and say, if someone who raped a 13-year-old girl, who raped a 13-year-old girl,
Speaker Sexton.
Thank you, Ms. Speaker. Welcome to the club. Let me just say, in that example, if you rape a 13-year-old girl, I don't care if it's your first time or your fifth time, it is atrocious the same. And you should not be given bail even on the first time in that offense. Should not, in my opinion. That's my example. We can agree to disagree on that. But at the end of the day, well, there's thousands of examples out there. We can go through it all day. Talk to your DA in Shelby County. Talk to your sheriff in Shelby County. Talk to your police chiefs in Shelby County. They will tell you tons and tons and tons of cases where that person should have been denied bail. You deny bail and keep people incapacitated or incarcerated who is afraid, you're afraid to put out on the streets. Everybody else you should be given bail to. They should have reasonable bail. They should be able to have bail. You can do a lot of different things.
Representative Dixie.
Thank you, Mr. Speaker. My question is, I think that we can all understand capital offense, the 1 through 6. The number 7 is the where I have questions about. Can you give me some examples or how many offenses fall under that category of number 7?
Speaker Sexton.
Can you tell me what your number 7 is? In the bill, it might be different than what's on the constitutional amendment.
Representative Dixie.
Oh, no, it says any other offense as of November 3rd, 2026, a defendant, if convicted, could not be released prior to the expiration of at least 85% of the entire sentence imposed.
Speaker Sexton.
Yeah, that's not a single offense. That's a series of offenses.
Representative Dixie.
I'm asking for some examples and how many offenses or how many offenses fall under that? Is it drug offenses? Is it only aggravated offenses? What type of offenses fall under that?
Speaker Sexton.
I'd be happy to read all of them to you. I don't think you would want me to because it would take out your time. But it would be things like sexual battery, aggravated sexual battery, promoting prostitution. Let's see what we got. Sexual battery by an authority figure, using a minor to produce, import, prepare, distribute, process, or appear in obscene materials, carjacking, aggravated vehicle homicide, second-degree murder, aggravated arson. The only drug offense in here is someone who is drug trafficking and has 2 or more prior convictions. That's the only drug offense that's listed in this. Criminal negligent homicide, aggravated human trafficking, a child sex predator, a multiple rapist. So there are violent crimes, and what we have in statute is those crimes that are deemed 85% time and 100% time are the crimes that are listed.
Representative Dixie.
So my question, again, thank you, I appreciate that, and there are some, but my thing, there are drug offenses in there. If someone was convicted before those crimes, and if those crimes had been 10 years ago or 15 years ago, are they still held to the same standard? Is there a time a factor of what time has gone by that it doesn't apply? What if someone had changed their lives and then they're accused of one of these crimes, not convicted, haven't had their due process, they're just accused, even though it's been 15 years or 20 years since their prior conviction? How is that appropriate, or how would that be handled under this particular?
Speaker Sexton.
Thank you. Well, this would not go into effect until after the people of Tennessee voted on it. So anything that happened after that fact would be under something different. The only drug crime in here, and I'll read it to you so you are very clear. The manufacture, delivery, or sale of a controlled substance as defined in 39-17-417, where the instant offense is classified as a Class A, B, or C felony, and the person has 2 or more prior convictions for the same manufacture, deliver, or sale of a controlled substance classified as a Class A, B, or C felony pursuant to 39-17-417 prior to or at the time of the committing the instant offense. But that deals with a certain level of drug trafficking. That's not your person who's on the corner of the street trying to sell drugs.
Representative Dixie.
So those offenses would include, I guess, opioids and marijuana, which would have fallen in the A, B, or C. Again, this is my question, is that if someone, especially in the state of Tennessee, when someone gets arrested, if you're riding with some guys, I'm riding with these 4 people around me right now. I may not know that she has some drugs on her, but we're in the car. But I may have been convicted of a felony 10 years ago. They're going to charge all of us with the same charge till they figure it out. I'm not going to be eligible for bail under this constitutional amendment. That's the issue that I have with there's a lack of due process. I appreciate you, answering this question, but there's too many unknowns that where something could happen and keep somebody and take them away from their livelihood. It'll take them out of their away from their jobs. It'll take them away from their families. And someone who could possibly be on the straight and narrow. But under this constitutional amendment, it will deny them that right of due process. That's why I do not agree with this bill. And I definitely don't agree with putting it into the Constitution.
Speaker Sexton.
I understand that you don't like this bill. It takes the judge to deny it, first of all. So the judge has the discretion and the capability to make that determination. If it's been 15 years, it's not an automatic. The judge can take that into account. You're minimizing the trust you have in the judge. That's what you're doing. You're minimizing the trust of the judge. The judge can take all that into an account. The other thing I will say is this drug offense in here is drug trafficking. So unless they were, as you say, trying to make an income, they had to be convicted of drug trafficking twice. This would be their 3rd time. So I don't know what kind of business they're running, but obviously it's not a normal business that anybody in this room is doing. But you have to be prior convicted of drug trafficking twice at a certain level. And the judge still has the discretion. It is not automatic.
Deputy Speaker Zachary.
Thank you, Mr. Speaker. Move previous question.
We have objection. We're on the board. All in favor of previous question, please vote aye when the bell rings. All opposed, vote no. Take the vote, Mr. Clerk.
Ayes 71, 22 nays.
Previous question prevails. Speaker Sexton to close.
Thank you, Mr. Speaker. I just want to remind everyone in this room, this is a bipartisan issue. Tennesseans, regardless of political party affiliation, or their politics, they agree with this direction. They agree with every single DA in our state, every single sheriff in our state, every single police chief in our state. And let me just have another example to close here. Everybody knows a couple of weeks ago, there was a driver who stole a car, a Jeep, in Nashville. That person drove that Jeep, ran a traffic light, and was speeding and hit a taxi cab. that carried two people from Florida and killed them. Killed them. Yes, the person had prior convictions. Yes, this person was a habitual criminal, which is what the judges are going to look at, to be honest with you, the vast majority of the time. That person who killed two people with that vehicle cannot be denied bail. Think about that. Two people visiting our state from Florida for tourism in our state in a taxi cab, going home from a night at Lower Broad, apparently. Someone who stole a Jeep, drove it through a traffic light at such a high rate of speed, drove that taxi cab through a business, through the cross exchange. And that person cannot be denied bail for that offense. All I'm asking for you to do is let the people of Tennessee vote and allow the judges who we elect, in most cases, who we elect to represent us, to make the decision to keep us safe. With that, I wish for your vote on this constitutional amendment.
Mr. Clerk, you recognize.
Mr. Speaker, the question was, does the sponsor of a bill get to close after previous question has prevailed? The proponent of the Rule 36, the proponent of the motion to amend resolution of the bill shall have the right to close the debate thereon, and no call for previous questions shall cut off this right.
All right, we're ready to vote. All those in favor of SJR 25, please vote when the bell rings. Those no, vote no also. Has every member voted? Does any member wish to change their vote? Take the vote, Mr. Clerk.
Ayes 84, 10 nays, 1 present, not voting.
After being read 3 times on these separate days, on 3 separate days, Senate Joint Resolution 25, having received the vote information by 2/3 of the members elected of the Tennessee House of Representatives of the 114th General Assembly, I hereby declare that it concurred in present Article 11, Section 3 of the Constitution of the State of Tennessee. Without objection, motion to reconsider is tabled. Leader Lambert, you recognize.
Thank you, Mr. Speaker. I move that we take up item number 1 on today's calendar, SJR number 1 at this time.
Call up the next bill, Mr. Clerk.
Mr. Speaker, that's Senate Joint Resolution 1 by Chairman Darby, a resolution proposing an amendment to Article 2, Section 28 of the Constitution of Tennessee to prohibit taxation of property by the state.
Representative Darby, you're recognized.
Thank you, Mr. Speaker. I request that the clerk read SJR 1 for its third and final reading.
Mr. Clerk, please read the resolution.
Senate Joint Resolution 1 on third and final reading. A resolution to propose an amendment to Article 2, Section 28 of the Constitution of Tennessee to prohibit taxation of property by the state. Whereas House Joint Resolution number 81 of the 113th General Assembly, which proposed amendment of Article 2, Section 28 of the Constitution of Tennessee, was considered and agreed upon by a majority of all the members elected to each of the 2 houses, as shown by the yeas and nays entered on their journals. And whereas such resolution proposing such amendment was published in accordance with Article 11, Section 3 of the Constitution of Tennessee, and whereas Article 2, Section 28 of the Constitution of Tennessee currently authorizes taxation of all property according to its value by any taxing authority, including the state, counties, and municipalities. and whereas the state can impose a property tax as it did until 1949 to all property in the state, and whereas in 1949 the legislature repealed the state's property tax, and whereas the current property tax is imposed at the local level at various county and municipal tax rates, and whereas the controlling and predominant purpose of the property tax is for local purposes, now therefore be it resolved by the Senate of the 114th General Assembly of the state of Tennessee, the House of Representatives concurring, that a 2/3 majority of all the members of each house concurring, as shown by the yeas and nays entered on their journals, that it is proposed that Article 2, Section 28 of the Constitution of the state of Tennessee be amended by deleting the following language from the first sentence. In accordance with the following provisions, all property, real, personal, or mixed, shall be subject to taxation, but the legislature. And substituting instead the following. In accordance with the following provisions, all property, real, personal, or mixed, shall be subject to taxation, but the legislature shall not levy, authorize, or otherwise permit any state tax upon such property, and the legislature. Be it further resolved that in accordance with Article 11, Section 3 of the Constitution of Tennessee, the foregoing proposed amendment shall be submitted to the people at the next general election in which a governor is to be chosen, the same being the 2026 November general election, and the Secretary of State is directed to place such proposed amendment on the ballot for that election. Be it further resolved that the clerk of the Senate is directed to deliver a copy of this resolution to the Secretary of State, with this final resolving clause being deleted from such copy.
Representative Darby, you're recognized.
Thank you, Mr. Speaker. SJR 1 has been a multi-year effort to include in our state's constitution the state of Tennessee should never collect a statewide property tax. Taking this belt approach allows local governments to continue to operate as normal while ensuring an additional burden is not placed on Tennessee property owners. I move to concur in SJR 1.
Any discussion? Representative Warner, you're recognized.
Thank you, Mr. Speaker. I move previous question.
We're on the board for previous questions. All those in favor, please vote aye when the bell rings. All opposed, vote no. Take a vote, Mr. Clerk.
Ayes 59, 32 nays.
Previous question failed. We're back on discussion. Representative Bain, you recognized.
Thank you, Mr. Speaker. So I was trying to figure out what this was for, and I know that next year is an election year, so perhaps it's a AFP mailer. But the question I have for you is, if it is a ban on property taxes, could this lead to businesses challenging what's left of the franchise tax, which includes a valuation on real property? So if I was a corporate lawyer, I might sue, threaten to sue the state saying that the Constitution prohibits taxation on real property as part of our franchise tax evaluation. So interested to hear what you have to say about that. Thank you.
Representative Darby.
Thank you, Mr. Speaker. There's no way that we can do anything to keep people from suing. There's nothing that we can do. But this right here, the excise, is that what your question was?
Representative Bain.
With regard to how the franchise tax is evaluated, that includes the valuation of property in that.
Representative Darby.
Thank you, Mr. Speaker. When I first ran this bill, my first call was to the comptroller because I wanted to make sure that nothing was going to jeopardize our AAA rating. And he said in no possible form. 3 weeks ago, I did the same thing just to see if anything has changed. And he said, no way. Nothing is going to change with our AAA rating because of this bill. But to answer your question directly on the franchise and excise, that's that tax is a privilege for doing business in Tennessee. I don't think that the land evaluation there is going to come into play.
Representative Bain.
So just to be clear, because we are now upwards of giving out almost $2 billion in these franchise tax refunds, that I just want to make sure that moving forward as part of this, that anyone who's listening, any corporations that are listening, that you do not intend to sue over the property stipulation of our franchise tax should this pass on a constitutional ballot. Thank you, Representative Darby.
Representative Darby. Representative Greg Martin, you're recognized.
Can you roll me one space?
Anybody, any other discussion? Representative Martin, you're recognized.
Call the question.
Any objection to the question? Seeing none, all those in favor of Senate JR 1, please vote aye when the bell rings. Those opposed, vote no. Is every member voted? Does any member wish to change their vote? Take the vote, Mr. Clerk.
Ayes 89, 6 nays.
After being read 3 times on 3 separate days, Senate Joint Resolution 1, having received a vote in the affirmative by 2/3 of the members elected to the Tennessee House of Representatives of the 114th General Assembly, I hereby declare it concurred in pursuant to Article 11, Section 3 of the Constitution of the State of Tennessee. Without objection, the motion to reconsider is tabled. Leader Lambert.
Thank you, Mr. Speaker. Move to take up item number 2 on today's calendar, SJR number 9.
Call up the next bill, Mr. Clerk.
Senate Joint Resolution 9 by Chairman Doggett, a resolution proposing amendment to Article 1, Section 35 of the Constitution of Tennessee relative to the rights of crime victims.
Representative Doggett, you're recognized.
Thank you, Mr. Speaker. I request that the clerk read Senate Joint Resolution 9 for its third and final reading.
Mr. Clerk, please read the resolution.
Senate Joint Resolution 9 as amended by the Senate on third reading. A resolution proposing an amendment to Article 1, Section 35 of the Constitution of Tennessee relative to the rights of crime victims. Whereas House Joint Resolution number 94 of the 113th General Assembly, which proposed amendment of Article 1, Section 35 of the Constitution of Tennessee relative to the rights of crime victims, was considered and agreed to by a majority of all the members elected to each of the 2 houses, as shown by the yeas and nays entered on their journals. And whereas such resolution proposing such amendment was published in compliance with Article 11, Section 3 of the Constitution of Tennessee. Now therefore, be it resolved by the Senate of the 114th General Assembly of the State of Tennessee, the House of Representatives concurring, that a 2/3 majority of all members of each house concurring, as shown by the yeas and nays entered on their journals, that it is proposed that Article 1, Section 35 of the Constitution of Tennessee be amended by deleting the section in its entirety and substituting the following. Section 35, that to preserve and protect the rights of victims of crime to justice and due process throughout the criminal and juvenile justice systems, a victim as defined by law and which may be expanded by the General Assembly shall have the following rights which shall be protected. 1, the right to be treated with fairness for the victim's safety and dignity. 2, the right, upon request, to reasonable notice of all public criminal proceedings and all public juvenile delinquency proceedings involving the accused. 3, the right to be present at all public criminal proceedings and all public juvenile delinquency proceedings involving the accused. 4, the right upon request to be heard in any proceeding involving release, plea, sentencing, disposition, and parole as well as any public proceeding when relevant during which a right of the victim is implicated. 5, the right to be heard and informed of all parole procedures, to participate in the parole process, to provide information to the parole authority, to be considered before the parole of the offender, and to be notified upon request of the parole or other release of the offender. 6, the right to be free from harassment, intimidation, and abuse throughout the criminal justice system, including reasonable protection as defined by the General Assembly from the accused or any person acting on behalf of the accused. 7, the right upon request to reasonable notice of any release, transfer, or escape of the accused or convicted person. 8, the right to full and timely restitution from the offender. 9, the right to a speedy trial or disposition and a prompt and final conclusion of the case after the conviction or sentence. 10, the right to be informed of the minimum sentence the offender will serve in custody and the scheduled release date. 11, the right to have the safety of the victim, the victim's family, and the general public considered before any parole or other post-judgment release decision is made. 12, the right upon request to confer with the prosecution. And 13, the right to be fully informed of all rights afforded to crime victims. A victim may assert the rights enumerated in this section not as a party, but in the manner further provided by the General Assembly, protecting the victim's right to standing. The General Assembly has the authority to enact substantive and procedural laws to further define, implement, preserve, and protect the rights guaranteed to victims by this section. This section must be interpreted to preserve and protect the rights of all persons to due process. This section, or any law enacted under this section, does not create a basis for vacating a conviction. This section does not restrict the powers of the District Attorney General or the inherent authority of the court. Other than as provided in the preceding paragraph, this section does not create a cause of action or claim for damages against the state or a political subdivision of the state, an officer, employee, or agent of the state or of any of its political subdivisions, or an officer or employee of the court. Be it further resolved that in accordance with Article 11, Section 3 of the Constitution of Tennessee, the foregoing proposed amendment shall be submitted to the people at the next general election in which a governor is to be chosen, the same being the 2026 November general election, and the Secretary of State is directed to place such proposed amendment on the ballot for that election. Be it further resolved that the clerk of the Senate is directed to deliver copies of this resolution to the Secretary of State, with this final resolving clause being deleted from such copies.
Representative Doggett, you recognize.
Thank you, Mr. Speaker. This constitutional amendment, known as Marcy's Law, is one that provides enforceable rights to victims of crime in Tennessee. In 1998, Tennesseans voted overwhelmingly to include specific rights for crime victims in our state's constitution. These rights are currently found in Article 1, Section 35. And by passing Marcy's Law, we can clarify and expand these rights and make good on Tennessee's clear intention to guarantee victims the rights that they deserve. This conversation is one that started back in 2021. The conversation led to Marcy's Law to be customized to Tennessee's specific needs and wants. It's not a cookie cutter approach or a one size fits all approach from a national group. Some of the things that Marcy's Law will help with is due process. Victims have felt like previous law did not allow them to be involved. And so 3 major changes that you might see from what we have today with what's being proposed here is notification upon request, the right to be heard, which gives victims standing, and the opportunity to be present in all public proceedings. Tennesseans recognize the importance of protecting the rights of victims. We overwhelmingly passed this amendment in the previous General Assembly, as well as 20 years ago when they passed a constitutional amendment to add additional protections for victims. We have the opportunity to improve upon these rights today by making meaningful and enforceable changes to better protect victims in this state. I want to say thank you to the chiefs and the sheriffs, the district attorneys general's conference, for they have been instrumental in this endeavor, the entire law enforcement committee. I also would like to thank Speaker Sexton for allowing me the opportunity to help guide this amendment throughout the legislative process, and also thank the Honorable Patsy Hazelwood for her commitment, for her leadership and conviction to get this ball rolling a few years ago. And with that, Mr. Speaker, I move to concur with Senate Joint Resolution 9.
Representative Doggett moves to concur in Senate Joint Resolution 9. Any discussion? Any objection to the question? Seeing none, all those in favor of SJR 9 vote aye when the bell rings. Those opposed vote no. Has every member voted? Does any member wish to change their vote? Take the vote, Mr. Clerk.
Ayes 93, no nays.
After being read 3 times on 3 separate days, Senate Joint Resolution 9, having received a vote in the affirmative by 2/3 of the members elected to the Tennessee House of Representatives of the 114th General Assembly, I hereby declare it concurred in pursuant to Article 11, Section 3 of the Constitution of the State of Tennessee. Without objection, the motion to reconsider is tabled. Leader Lambert, you're recognized.
Thank you, Mr. Speaker. Move to take up item number 79, House Bill 894 at this time. Item number 79.
Call the next bill, Mr. Clerk.
Item 79, House Bill 894 by Chairman Todd, relative to the Board of Groundwater Management.
Representative Todd, you're recognized.
Thank you, Mr. Speaker. I move passage of House Bill 894 on third and final consideration.
Representative Todd moves passage, properly seconded. Mr. Clerk, call for the First Amendment.
House Ag and Natural Resources Committee Amendment number 1.
Vice Chairman Martin, Hamilton, you're recognized.
Thank you, Mr. Speaker. We move to withdraw.
Without objection, amendment number 1 is withdrawn. Next amendment, Mr. Clerk.
House Government Operations Committee Amendment number 1, filed as House Amendment 2.
Chairman Lafferty, you're recognized.
Thank you, Mr. Speaker. This amendment makes the bill, and I defer to the sponsor for further explanation.
Chairman Lafferty moves adoption of amendment number 2, properly seconded. Any discussion on the amendment? All those in favor of amendment number 2 say aye. Aye. All those opposed say no. We adopt. Next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Representative Todd, you're recognized.
Thank you, Mr. Speaker. As amended, this bill vacates the Board of Groundwater Management, which has been put in sunset, and it reconstitutes this board. It has a similar makeup that it did previously, but with an alternate from each grand division, and sets some requirements for those members of that board and some additional duties. We're continuing duties they've had since, I think, at least 60 years, and are expanding those just slightly and giving them some clear direction on how their testing and their testing process should go. And with that, I'll be glad to take any questions.
Representative Todd renews his motion. Any discussion on the bill? Representative Hardaway.
Thank you, Speaker. To the sponsor, these appointments, are they done with any consultation with the legislative delegations from these various grand divisions?
Chairman Todd.
Thank you, Mr. Speaker. These nominations by the governor and by the speakers are similar to other nominations that they have, other appointments that they have. There's no difference.
Representative Hardaway.
Thank you. I'm going to suggest that perhaps that we revisit not merely this one, but all of those with similar appointment type of process, that the delegations from the west, the delegation from the west, the east, and the middle, that the appointments are done with consultation with those legislators. But thank you very much.
Chairman Todd.
I could not disagree. I renew my motion.
Thank you. Any further discussion? Seeing none, any objection to the question? Seeing none, we're voting. All those in favor of House Bill 894 as amended, vote aye when the bell rings. Those opposed, vote no. As every member vote, as the members change their vote. Brick and I. Mr. Clerk, please take the vote.
Ayes 81, 11 nays.
House Bill 894, having received constitutional majority, I hereby declare passed without objection. The most read series table. Call up next bill, Mr. Clerk.
Brings us back to item 47. Item 47, House Bill 42 by Chairman Hicks, relative to compensation paid to firefighters for certain conditions or injuries. Mr. Speaker, Senate bill is on the desk.
Chairman Hicks, you're recognized.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 288.
Chairman Hicks moves substitute and conform Senate Bill 288 without objection. So ordered. Chairman Hicks.
Thank you, Mr. Speaker. I move passage of Senate Bill 288 on third and final consideration.
Chairman Hicks moves passage of Senate Bill 288 on third and final consideration. By second, Mr. Clerk, call up First Amendment.
Mr. Speaker, no amendments final.
Chairman Hicks, you're recognized.
Thank you, Mr. Speaker. This legislation adds prostate, breast, and pancreatic cancers to the list of cancers included in the Berry-Brady Act. And with that, I renew my motion.
Chairman Hicks renews his motion. Any discussion on the bill? Seeing none, any objection to the question? Seeing none, we're voting. All those in favor of Senate Bill 288, vote aye when the bell rings. Those opposed, vote no. As every member vote, as every member wishes to change their vote. Mr. Clerk, please take the vote.
Ayes 94, no nays.
Senate Bill 288, having received constitutional majority, hereby declare passed without objection. The most read series table. Call up next bill, Mr. Clerk.
House Bill 504 by Chairman White and others, relative to future teacher scholarships.
Chairman White, you're recognized.
Thank you, Mr. Speaker. Move passage of House Bill 504 on third and final consideration.
Chairman White moves passes, probably seconded. Mr. Clerk, call up First Amendment.
House Education Committee Amendment number 1.
Vice Chairman Raper, you're recognized.
Thank you, Mr. Speaker. Move to adopt and defer to the sponsor for further explanation.
Vice Chairman Raper moves adoption of Committee Amendment number 1, probably seconded. Any discussion on the amendment? Seeing none. All those in favor of Committee Amendment number 1 say aye. Aye. All those opposed say no. The ayes have it. You adopt it. Next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Chairman White, you're recognized.
Thank you, Mr. Speaker. Members, House Bill 504, this deals with it's called a Future Teacher Scholarship Program. Back in 2023, we passed legislation for those who want to go into the teaching profession in their junior and senior year. There would be a scholarship available for them if they taught in a at-risk or rural community. This year, we're adding to that. As you know, as you go around the state, we have a lot of teachers teaching on permits. And so that means that you have a 3-year permit. And if you're teaching on a permit and you have your undergraduate degree, but you do not have your teaching licensure, you now can take this grant, which is $3,500 a year, to apply and go back and get your teacher licensure, your initial teaching licensure. And with that, I renew my motion.
Chairman White renews his motion. Any discussion on the bill? Seeing Representative Hardaway.
Thank you, Speaker. Chairman White, is this for the whole state, sir?
Chairman White.
This one is, they're not all, but this one is, yeah.
Representative Hardaway.
That's all I need to know. I like that. You seem to be falling into a routine. I'd love to see you keep that going. Thank you, Speaker.
Chairman White.
Thank you. Renew my motion.
Any further discussion? Seeing none, any objection to the question? Seeing none, we're voting. All those in favor of House Bill 504 as amended, vote aye as the bell rings. Those opposed, vote no. As every member voted, does any member wish to change their vote? Mr. Clerk, please take the vote.
Ayes 94, no nays.
House Bill 504, having received constitutional majority, hereby declare passed without objection. Motion to reconsider is tabled. Call up next bill, Ms. Clerk. Oh, Leader Lamberth, you're recognized.
Thank you, Mr. Speaker. Move to take up item number 76, House Bill 479 at this time.
Without objection, so ordered. Chairman Hicks, you're recognized. Oh, Ms. Clerk, call up next bill.
Item 76, House Bill 479 by Chairman Hicks. Relative to the Tennessee National Guard Service Members Medical Readiness Act.
Chairman
Miss-
Hicks, thank you. Ms. Clerk, oh, sorry. Chairman Hicks, you're recognized.
Thank you, Mr. Speaker. I move passage of House Bill 479 on third and final consideration.
Chairman Hicks moves passage, probably second. Mr. Clerk, call up First Amendment.
House Finance, Ways and Means Committee Amendment Number 1.
Chairman Williams, you're recognized.
Thank you, Mr. Speaker. I move to adopt.
Chairman Williams moves adoption of Committee Amendment Number 1, probably seconded. Any discussion on the amendment? Seeing none. All those in favor of Committee Amendment Number 1 say aye. Aye. All those opposed say no. The ayes have it. You adopted. Next amendment, Ms. Clerk.
No further amendments, Mr. Speaker.
Chairman Hicks, you're recognized.
Thank you, Mr. Speaker. Members, this bill enacts the Tennessee National Guard Service Members Medical Readiness Act, which creates within the military department the Tennessee National Guard TRICARE Premium Reimbursement Program to award reimbursement grants to a member of the adjunct general through written policies and guidelines for reimbursement of premium paid for individual coverage through the TRICARE Reserve Select Program or Dental Program. With that, Mr. Speaker, I renew my motion.
Chairman Hicks renews the motion. Any discussion on the bill? Chairman Williams, you're recognized.
Thank you, Mr. Speaker. Just want to stand up and say what a good idea this is. Chairman Hicks has worked really hard on this. What this allows us to do is sometimes our National Guardsmen are moving on duty and off duty. This allows us to help offset their premiums so that they're not, and that them and their families are not without health care coverage. So I really appreciate this bill and the sponsor for his hard work making sure it gets passed.
Chairman Hicks. All right, Representative Fritz.
Thank you, Mr. Speaker. And as a former National Guardsman, I want to tell you how much I appreciate this. There's probably about 10,000 Tennesseans that appreciate what you're doing here now. And you're taking the load off, in many cases, the ones that bear the most, the families. So thank you so much for bringing this.
Chairman Hicks, very good. Any further discussion? Seeing none, any objection to the question? Seeing none, we're voting. All those in favor of House Bill 479 as amended, vote aye. When the bell rings, those opposed, vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, please take the vote.
Ayes 94, no nays.
House Bill 479 having received a constitutional majority, hereby declare passed without objection. The motion to reconsider is tabled. Call up next bill, Ms. Clerk.
Item 50, House Bill 541 by Chairman Vaughn, relative to wetlands. Mr. Speaker, the Senate bill is on the desk.
Chairman Vaughn, you're recognized.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 0670.
Chairman Vaughn moves substitute form Senate Bill 670, properly seconded without objection. So ordered. Chairman Vaughn.
Thank you, Mr. Speaker. I move passage of Senate Bill 0670 on its third and final consideration.
Chairman Vaughn moves passage of Senate Bill 670 on third and final consideration, properly seconded. Mr. Clerk, call up First Amendment.
House Agriculture and Natural Resources Committee Amendment Number 1. Mr. Speaker, it's the same as Senate Amendment Number 2.
Chairman Todd, you're recognized.
Thank you, Mr. Speaker. Same as Senate amendment. Move to withdraw.
Without objection, Committee Amendment Number 1 withdrawn. Next amendment, Mr. Clerk.
No further amendments, Mr. Speaker.
Chairman Vaughn, you're recognized.
Thank you, Mr. Speaker. Present day law or regulations, not law, which is important. Regulations identifies isolated wetlands as waters of the state, regardless of their benefit to the environment. Things ranging from tractor ruts, clogged ditches, feed lots, and roadside ditches are treated the same way as high-quality ecosystems throughout our state. What this bill seeks to do is bring our laws into alignment with other states and many of our border states, which do not regulate these isolated wetlands at all. There's 24 other states throughout the union that do not regulate these wetlands. And again, isolated wetlands. And that was originally what I wanted to do with my bill. However, the bill that I've got in front of you today has been brought through a series of compromises. And to show you what an egregious affront to property rights I believe this issue is,
just the little bit that we're moving the needle back is going to have a profound impact to landowners across our state. In 2023, the Supreme Court ruled that isolated wetlands were not waters of the U.S. and removed them from the Clean Water Act. Mr. Speaker, I'll be happy to stand for questions, and I renew my motion.
Chairman Vaughn renews the motion. Any discussion on the bill? Representative Pearson.
Thank you, Speaker and sponsor, and I know you've been presenting this for a while. I do believe the importance of protecting our wetlands and importance of protecting our environment and doing the work of conservation is a part of our responsibilities here in decreasing sort of the protections currently for isolated wetlands. I know you said the Supreme Court is in essence in favor of this move. How many acres, what's going to be the consequence of this for people across the state of Tennessee that whose isolated wetlands on your property or land would no longer be protected?
Chairman Vaughn, you recognize.
Well, I have seen differing amounts of this, but what one has to keep in mind with this is that's a number that's very, very difficult to quantify. In order to qualify as a wetland, you've got to have three different data points that have to be satisfied. Number one is the amount of how hydric the soil is, how much water it contains, the type of vegetation that grows there, and then also the ability for that water source to replenish itself. So I've seen some pretty bold estimates about what this will do for people, but it's difficult to quantify because each of these areas have to be identified and then submitted to TDEC or the Corps of Engineers. But the Corps of Engineers is no longer taking jurisdiction unless they find it to be connected to a water of the U.S. So I can't give you an estimate, and I would be willing to poke holes at estimates that I've seen out there as well, just because from a scientific standpoint, they haven't been on ground checking each of these areas.
Representative Pearson.
And so what benefit do you think that there is to no longer having this protection that we currently have for isolated wetlands through TDEC?
Chairman Vaughn.
It'll remain, it is part of a cost savings program that hopefully will lower the cost of housing eventually throughout this state. We've got an affordable housing crisis throughout our state. This is one of those areas to where the time that is spent in permitting for this is tremendous. The costs of mitigation for areas that may not have even been wetlands 5 years ago, but today meet the standard. And so what I'm trying to do is bring balance between what actually is helpful to the environment and therefore future generations and things that are just needless inflationary factors of trying to deliver housing to our people. And it's not just housing. It could be anything associated with even residential. If let's say I owned 100 acres and that's not in row cropping, then it still impacts me the same way.
Representative Pearson.
Thank you. So for development purposes, this would be one of the main benefits of us no longer having the same level of protection for isolated wetlands?
Chairman Vaughn.
That is correct. It could be either housing, it could be industrial, it could be commercial, it could be road networks, it could be infrastructure for cities, because two of the largest beneficiaries from this, in my opinion, my belief is going to be TDOT and local governments.
Representative Pearson.
Thank you for answering those questions. Look, this is my challenge with this legislation. I don't see where, even in the articulation, this is going to help with permitting, this is going to help with more in future development, but we aren't talking about how this is going to improve the protections for people. This is going to improve the quality of the environment, the places where we live, the places in Tennessee that are so beautiful for all the things that people do, whether it be hunting, fishing, wildlife, and those sorts of things. And you mentioned something that 5 years ago, certain things weren't wetlands, but today they are. But I think that's important to note, right? In Memphis, as you know, in Shelby County, we just got some of the most rainfall that we've ever had due to the effects of climate change, due to the effects of the environment that we are living in being quite different than it was 5, 10, 15, 20 years ago. And so I think making drastic changes to the protections of the Tennessee Department of Environment and Conservation for corporations or for individuals to build more housing isn't proper. I think if these changes are being made to improve our environment, is being made to improve the quality of life of people in Tennessee, that's one thing. But if we are changing the protections of our natural resources on behalf of corporate entities to be able to make more profit, I have a significant problem with that. And I don't think that is the type of work, the type of legislation that I can support or that we should support. And so for that reason, I want to keep the highest level of protections as possible. So I can't support your legislation.
Chairman Vaughn.
Thank you. I appreciate that. I was really counting on your vote on this one, but as the pendulum swings, in 1977, the state passed its first Clean Water Act or something along those lines, dealing with the Toon-Teague landfill from Velsicol in Hardeman County, my home county. So I understand these issues very well. But what happens is there's been 50 years of pushing in one direction, and the direction that it's been running over has been people's private property rights. And so what this is doing is finally standing up and saying, hey, why are we doing this? Is it worth what we're doing? Because what we're doing is trampling people's private property rights, especially whenever you consider the fact that I may own a piece of property, and because someone else says that there is something on my property that has resource value, that I'm going to have to pay a third party to be able to use my own property. That does not compute, doesn't find that to be logical. And if you think about it, the state has $18 million in a wetland reserve fund right now, and they don't want isolated wetlands. So they're not that big a resource value. And I can tell you too, colleagues, this is such a watered down version of what I wanted to do that it's, I listened a lot to what it would take to get this bill approved. And I think we're going to, even the little bit that we're moving the needle, and it's a tiny nudge, is going to pay huge dividends. And hopefully it's going to lead to us questioning other things in the future, saying, I know that this is well intended, but is it working? Does it produce results? And at what price do those results come? And so that's what this bill is about. And that's why I'm semi-passionate about it.
Chairman Clemens.
Thank you, Mr. Speaker. And Mr. Sponsor, I know when you say this bill's watered down, I know you well enough to know you actually intended that as a pun. So, I know, and again, I realize you're not counting on my vote either, but the issue with this bill is where we face ourselves. Since I entered this body, I've been working on the housing shortage that has been facing not only my county, but a lot of the counties across the state of Tennessee. That's a real issue. But we have to find that balancing, that balance between addressing that housing shortage and density and development. And I also respect and understand the argument for private property rights, but I do think there's a difference in private property rights. Somebody owns a piece of property and they want to do whatever they want on their property versus developers who buy spec property to build 200 houses on. Those are two different things. And what we're doing here isn't necessarily the primary focus isn't on protecting the private property rights of an individual's farm or family farm or something like that. It's eliminating costs for developers who want to buy a bunch of land and make a profit on it. And I understand that's a business, and I respect that business. However, we do have to find that balancing line between protecting our wetlands, protecting the environment, and addressing the housing shortages and producing more housing stock. I'm not sure this bill gets there because right now, anybody will tell you, anybody on any insurance company or any market earnings call right now, the biggest concern is the cost of insuring flooding because of the increased rainfall, the increased flooding, and every wetland that we develop, every wetland, regardless of how it's defined, that gets paved over, it creates a bigger issue for the state of Tennessee, existing private property owners. So if I own my family farm and somebody else wants to come pave the whole 100 acres next to me, that creates a problem for me. Those are my private property rights that are being screwed over in the name of somebody else's who's looking to make a a profit's private property rights. Those are two different things. And so when we start talking about eliminating permitting, notification, mitigation requirements for certain wetland categories that will result in fewer applications and all this stuff detailed in this fiscal note, eliminating mitigation, credit cost. This is all it sounds great, and I'm all for deregulation, but to the extent it harms existing private property owners' property, to the extent it causes more flooding, to the extent it threatens our environment even more, that's very problematic, especially if the only incentive is a bigger profit for people who are buying mass quantities of land for spec purposes. That's my concern. And I'm all for figuring out something that balances these interests, but I don't think this bill gets us there. I understand you worked hard on it. I understand it's watered down, as you say, purposely or not. I just continue to have concerns, sincere concerns about the impact on our environment and continued increased flooding of existing private property owners' property. So with that, that's my concern. And if you could address those, I'd appreciate it.
Chairman Vaughn.
Sure. Let me tell you exactly what this bill does to maybe I can convince you. I don't know. You seem to be pretty set in your ways, but let me see if I can convince you. What this bill does, it requires annual reporting where we're going to find out where TDEC is directing mitigation money so that we can ascertain which NGOs are profiting in the mitigation business. It acknowledges and differentiates between the qualities and the value of various types of wetlands and varies the permitting requirements based upon the quality and value of those. We also reduce or eliminates the amount of mitigation required for the alteration of the lowest quality of those. It also presumes that a wetland resource inventory report prepared by a third-party wetland professional is correct if conducted in accordance with the specified methodology by the department. And then, like I said, we believe that it's going to lower bureaucratic costs. So one thing that I do want to address, though, and that is if this body is serious about dealing with flooding across the state of Tennessee, TDEC is not the vessel for that. TDEC deals with water quality. If this body wants to take up the discussion of a stormwater detention plan that is voluntary and that if we can incentivize it for various parts of the state which do not have stormwater detention, that's an entirely different study and an entirely different line of reasoning. And I find that to be reasonable. I think that somebody needs to be raising those points because some of this flash flooding that's occurring, I don't think stormwater detention would help it, but I do think it would have more of an impact than concerning about whether or not a tractor rut is somebody's paying a company $50,000 to fill in a tractor rut.
Chairman Todd.
Thank you, Mr. Speaker. I don't know that I've ever had a situation come up before where I might need to declare a conflict because a bill was actually going to hurt my business. Now, my private business, we have done some work around wetland mitigation before, and I know that may garner some support from the other side of the aisle that was unexpected, but I do appreciate this bill. I certainly, like the sponsor, hoped that it would go further, similar to our sister states, but that just wasn't in the making right now. You've heard some questions and some comments about wetlands and flood mitigation, and as the sponsor just alluded to, the state of Tennessee's policy by law has for many, many decades been to regulate water quality, not quantity. That is a huge difference. If we regulate water quantity in the state, you have now put the state of Tennessee in a position to practically own and control every inch of property in this state. And I don't think anybody in this chamber would really want to go down that road. So I do appreciate the sponsor's approach to this. It's been very measured. We've had all the stakeholders at the table for a couple of years now. And I think this is a very good first step, as the sponsor mentioned, and look very much forward to continued work on this topic so that we can free up more private property and stay within the bounds of water quality issues that we already have a policy for. So thank you, Mr. Speaker. I fully support.
Chairman Vaughn.
Thank you, Mr. Speaker. And for those who are are concerned. I've got good news for you. Even if we pass this bill, we will still have some of the strictest isolated wetland laws in the Southeast United States, even after we pass this. So anyway, that's my answer to that one, and I appreciate the chairman's support. I want to say that Chairman Todd and Chairman Grills latched onto this issue and understood it very thoroughly from the very beginning, and I appreciate their support throughout the process.
Chairman Williams.
Thank you, Mr. Speaker. Thank you, Chairman Vaughn, for this bill. I have, obviously in my line of full-time work, I have an opportunity to deal with wetlands probably more than most. And it's been one of the things that I really like about this bill is it brings predictability. If you own property now and you have a wetland on it, no one's saying you can't manage the wetland and keep it forever. All we're saying is this is creating a predictable end for those people who wish to eliminate or buy wetland banks somewhere else. I do think it's important to note that even though the fiscal note says it's going to save $330,000 to the state this year, TDOT expects that it could save them as much as $1.3 million a year just in buying wetland mitigation bank credits, dealing with these wetlands, which is really important, all without impacting the overall consistency of the wetland. One of the things that the bill doesn't do that I shared with the sponsor that I really think is important, I don't think you ought to be able to, that I hope to have a discussion about in out years, I don't think you ought to be able to determine wetlands in the state and also sell wetland credits, wetland bank credits. I think if it's like the fox guarding the hen house. If you have the ability to go out and determine a wetland's 2 acres and you have to buy 5 acres worth of wetlands to replace that wetlands, and you say, oh, here's my bill for delineating your wetlands, and here's a bill for 5 acres of my wetland bank that I own, there's something wrong with that. And we shouldn't be doing that at all. And so I know this bill doesn't go as far as he hoped it would go, but I think defining what individual isolated wetlands are goes a long way in determining where we can get in the future. And so I look forward to working with the sponsor, and I hope the members will support this. I think it's really challenging whenever we go into our communities. And in my own instance, bought a piece of property, had a farm pond on it. I told the sponsor about this, had a farm pond on it. I went to divide it in a few lots for entry-level income homes in my district, and I was told, no, that's waters of the state. It's a 2,000 square foot pond. And so I thought, this is a farm pond. We built a farm pond for cattle, the people before me did, and I couldn't release the water out of the farm pond to sell 2 more lots. And so this will eliminate a lot of the challenge out there. I do think it'll free up a lot of property in our communities that is considered blighted now because of the karst soils or wetland determination that's been on in the past. So I appreciate the sponsor in this bill and look forward to seeing it going forward.
Chairman Vaughn.
Thank you for your support.
Representative Burkhart.
Thank you, Mr. Speaker. I move previous question.
Previous question been called. Is there objection? Seeing none, we're voting. All those in favor of Senate Bill 670 vote aye when the bell rings. Those opposed vote no. As every member voted, does any member wish to change their vote? Ms. Clerk, please take the vote.
Aye 71, 21 nays, 1 present not voting.
Senate Bill 670 having received a constitutional majority, I hereby declare passed by objection. Most reconsider table. Call next bill, Ms. Clerk.
Item 51, House Bill 542 by Chairman Vaughn, relative to utilities.
Chairman Vaughn, you're recognized.
Thank you, Mr. Speaker. I move passage of House Bill 542 on third and final consideration.
Chairman Vaughn moves passage. Bobby seconded. Ms. Clerk, call First Amendment.
House Commerce Committee Amendment number 1.
Vice Chairman Bricken, you're recognized.
Thank you, Mr. Speaker. I move to adopt and defer to the sponsor for a further explanation.
Vice Chairman Bricken moves adoption commitment number 1. Bobby seconded. Any discussion on the amendment? Seeing none, all those in favor of commitment number 1 say aye, aye. All those opposed say no. The ayes have it. You adopt the next amendment, Ms. Clerk.
No further amendments, Mr. Speaker.
Chairman Vaughn, you're recognized.
Thank you, Mr. Speaker. Folks, we all know what a great job our utilities do, and our linemen go out and get us reconnected back during the times of peril. And we certainly appreciate that. But what has come to my mind is that we do grant the license for these folks to operate as monopolies. And so I typically find that anytime we can put any type of market force into an equation, then the customer gets better service. And so what this bill pretends and what we're proposing is that all the utility companies throughout the state of Tennessee will have to offer a process by which a customer can self-install their own utilities. It will come off an approved contractor list. They'll divide that. And this is something that probably 80% of the utility companies throughout the state already do, but there are people who are holding out. And what the purpose behind this is to have transparency in cost, because again, these monopolies provide this service. So as this is proposed, these folks would have to come up with a system by which you could take a price from a private contractor off an approved list, and they would have the right to, you'd have the right to install them and pay for it yourself. And then there's requirements as far as insurance, bonding, guarantee, warranty, acceptance by the utility. And as a matter of fact, we've had some tell us that the requirements that we're approving in this would actually help them with some of their contracts now. So anyway, that's the purpose behind the bill. And again, it's hopefully the market forces in this will drive down costs of utility extension to where we can, again, pass those savings along to the end user. And that's, with that, Mr. Speaker, I renew my motion.
Chairman Vaughn renews the motion. Any discussion on the bill? Representative Hardaway.
Thank you, Speaker, and I appreciate the sponsor bringing a bill that maybe I can support. Will this bill bring competition to MLG&W?
Chairman Vaughn.
No, sir. But what it will do, it's an electrifying bill, so I would hope that you would sponsor it. You could co-sponsor it with me. What it will do is it will allow, if let's say that you, Representative Hardaway, were going to construct a facility of some type, and MLG&W gives you their cost estimates, which, by the way, are lump sum cost estimates with no explanation of where the charges originated. This would allow you to go out and have that same project taken from a list of their approved vendors, have that project bid and determine whether or not the utility or your private contractor could install it at the best rate.
Representative Hardaway.
So in one sense, it allows for competition and construction projects that MLG&W would be involved in.
Chairman Vaughn.
That is correct, sir. And they have told me, I received correspondence saying that they were in the middle of developing this plan, but hopefully this will help make sure that that plan becomes reality.
Representative Hardaway.
Well, I support bringing market forces to MLG&W and their monopoly. Thank you. Thank you.
Representative Pearson.
Thank you, Speaker and sponsor. Shelby County, Memphis has some of the highest percentages of income going, highest energy burden, percentage of people's income going to pay for utilities. And so I do think it's necessary that something happen to help people to pay less. I don't know if this legislation is going to specifically address that, though know that that is something that is important to me too. I'm curious about the approved vendor list. It says they have 10 days in order to respond. So if someone wants to be a utility vendor, they go to the public utility for the approval or the denial, and say, for instance, MLG&W would have 10 days to decide whether or not they could be a vendor in the city or county?
Chairman Vaughn.
No, sir, that's not the intent. I believe if you take another look at it, they have 10 days to approve. When you notify them that you want to use a third-party contractor, they have 10 days to approve that contractor, the contract you've got with them, or it is considered approved already, so that we don't get caught up in the bureaucratic maze. But the 10 days doesn't have to do with the formulation of the list of approved. It just has, they have to respond to your notification that you have bid this and you're going to award this to Pearson Electric. And so and if they don't come back and say, hey, Pearson has just been removed from our list due to this failure, so they're not on the list. But if they don't say anything back to you within 10 days, then you're approved to go ahead and start that contract process.
Representative Pearson.
Does this vendors list already exist, or are the vendors coming from people who are doing certain projects, developing and things like that?
Chairman Vaughn.
No, sir, we're asking them to develop this, to promulgate this list, to put it together. And there are people who do these services throughout the country. If you remember, whenever a storm comes through, you see all the bucket trucks running up and down the interstate, people going where storm damage has occurred. So there are private businesses that do this type of construction. And so what we would have them do is them set up their own requirements for being on the list, approve the list, make it noted public, and then from that point forward, people would know who they could call for pricing.
Representative Pearson.
Thank you. So the public utility is going to create a list of potential vendors for consumers to be able to use outside of the public utility, right? Okay, got it. One other concern that I have is if you are developing this, constructing whatever company, as you were using in your previous example, MLG&W's approver for the vendors is out for whatever reason, or there's a backlog of reviewing and approving these projects, a person will not have to go through the public utility at day 11 to start constructing, say, in 2 million square foot building, if they don't have approval by day 11. Is that right?
Chairman Vaughn.
Not necessarily the building, but the service to the building. Because the utility service, and it's not only electric, this could be gas, water, sewage, whatever has to do with.
Representative Pearson.
Thank you. So this is the contention. You can have 100 different vendors, right, who MLG&W says are possible to be used, but then they can all have their own projects tapping into a public system that taxpayers pay for. So you can have private companies attaching into a public utility, doing what we hope to be a good job, but there's no quality control, there's no check on that outside of whether or not their application is being approved. And so it worries me that private companies might have access to our public utility in the ways that a public utility does for all of the reasons that they have been created.
Chairman Vaughn.
This process allows for or requires these utilities to provide specifications, inspection. There's a test. They require testing of the system. So they have to accept the system. And then beyond that, these systems are guaranteed for the full year following the acceptance by the utility. So it will not be in a vacuum. It won't be like suddenly somebody drives up and says, oh, wow, there's a 3-phase line running a half a mile. I didn't know where that came from. And I can understand your concern, but that's not the way this would operate. And I will have to say that I do appreciate the assistance on this bill. When I first conceived of this, I talked to the Utility District Association, the Metropolitan Power folks, as well as the electric co-op folks. And so I told them what the basis of what we want, what I was trying to do, and much of this is their language that they provided back to us on how it would best not disrupt their operations. Because I think you're speaking to the need for reliability from these providers. And that is exactly what we believe we've gotten. We believe that we have introduced market forces, but yet still will not mess with the reliability of the service that the customers have. And again, this will be dedicated to after the customer bills it, it becomes the ownership of the utility district. And our hope is that this will allow some utility districts to become more predictable in their reliability and service of other customers, as opposed to having to meet the mandates of demand where the same people that are installing the lines are the same people maintaining them, so that they can rely on maintenance and then knowing that outside forces will be doing the initial install. But again, it will be it'll be in accordance with their specifications, in accordance with their testing and acceptance of that system.
Representative Pearson. Representative Pearson. Oh, we're off time. I'm sorry. That was on his. Sorry about that. My fault. Thank you. Representative Travis.
Thank you, Mr. Speaker. Move previous question.
Previous question been called. Is there objection? Seeing none, we're voting. All those in favor of House Bill 542 as amended vote aye when the bell rings. Those opposed vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, please take the vote.
Aye, 77, 13 nays.
House Bill 542, having received constitutional majority, hereby declare passed without objection. Most reconsider is tabled. Let the journal reflect Representative Halsey is excused. Call up next bill, Ms. Clerk.
Item 52, House Bill 543 by Chairman Vaughn, relative to sewer systems. Mr. Speaker, the Senate bill is on the desk.
Chairman Vaughn, you're recognized.
Thank you, Mr. Speaker. I move to substitute conform to Senate Bill 1138.
Chairman Vaughn moves substitute conform to Senate Bill 1138, probably seconded without objection. So ordered. Chairman Vaughn.
Thank you, Mr. Speaker. I move passage of Senate Bill 1138 on its third and final consideration.
Chairman Vaughn moves passage of Senate Bill 1138 on third and final consideration. Probably second. Ms. Clerk, call First Amendment.
House Agriculture and Natural Resources Committee Amendment Number 1. Mr. Speaker, it's the same as Senate Amendment Number 2.
Chairman Todd, you're recognized.
Thank you, Mr. Speaker. Same as Senate amendment. Move to withdraw.
Without objection, Amendment 1 withdrawn. Next amendment, Ms. Clerk.
No further amendments, Mr. Speaker.
Chairman Vaughn, you're recognized.
Thank you, Mr. Speaker. This bill is kind of a continuation of a few years back. Due to the leadership of Chairman Boyd, we've put together Tennessee Board of Utility Regulation throughout this that handles, I guess, management or oversight and grievances with regards to both water and wastewater systems in the state. What Senate Bill 1138 does says that if you operate a sewer system outside a political subdivision for over 25 years, that before you can valve that off or stop that service, you've got to present your case to the Tennessee Board of Utility Regulation. And so that's the first part of it. The other is that if you have an existing gravity sewer line on your property that has been installed there for the use of whatever utility that has put it there, even if in the easement documents that are recorded for the encumbrance, you have the right as the property owner to tie into that sewer should there be capacity in that sewer. So that, because what we're seeing is, and it's not just, this is not just a West Tennessee issue. My business is across the state, is that one thing that I'm trying to get at here is the de-weaponization of utilities across the state, because municipalities are utilizing utilities to impact land use issues outside their boundaries of jurisdiction. And so what I'm trying to do with this is let's bring order into this to where if you have granted an easement to somebody and you have a sewer line there, if there's room in it, you should be able to put your sewage in there. And it's just common sense, but that's not the way that this is being regulated around the state. And so what we're trying to do is just slowly but surely bring order into that space. And with that, Mr. Speaker, I'll be happy to answer any questions.
Chairman Vaughn renews his motion. Any discussion on the bill? Chairman Clemens.
Thank you, Mr. Speaker. I'm trying to get my head around this. So if a municipality owns a municipal sewer system for over 25 years and has operated that sewer system outside of its municipal boundaries for over 25 years, does this bill treat that municipality as a municipality or a utility district in terms of someone who isn't a municipal resident wanting to connect to that sewer system?
Chairman Vaughn.
Unless the pipe is on their property, it does not address that at all. What this is saying is that you can't stop service to the areas that you install the line in. Well, you can. You just got to present your case to the Tennessee Board of Utility Regulations before you do and demonstrate why it's in your interest and the public interest to stop that service. The connection is only a physical connection on the property owner whose property's been encumbered by the sewer pipe itself.
Chairman Clemens.
Thank you, Mr. Speaker. But does it treat the municipality as a municipality or as a utility district in that context?
Chairman Vaughn.
It would be a utility system because TBOR regulates both municipal systems as well as what used to be, well, they still are utility districts, but we have one regulatory body who controls all of that. So they would be treated the same regardless of what type of system they were.
Chairman Clemens.
Thank you, Mr. Speaker. And I couldn't help but notice in this fiscal note where it says this legislation could reasonably result in significant increases in local expenditures for Memphis to expand sewerage services in areas outside the corporate boundary of the city. Can you address how we expect Memphis to address those increased expenditures because they could be significant according to this fiscal note?
Chairman Vaughn.
Our fiscal review department does a great job, but sometimes I don't think they, even after further explanation, that they truly grasp the concept of this, of certain pieces of legislation. I think this is one of those cases. This bill does nothing to require expansion of any type. What it does do is say is if you have a sewer line that is fed by gravity on your property, that is, you could get off the septic tank and put your waste stream into that sewer. That's all we're talking about doing with this bill, other than the fact of, hey, if you've got it outside your system, if you're operating a sewer system outside your corporate boundaries, then don't cut it off until you get approval from TBOR to do so and present your case on why it's germane for you to end that service.
Chairman Clemens.
Thank you, Mr. Speaker. So isn't it possible that if they're required to allow those individuals to tap into that pipe, that they could end up having a capacity problem to the point where they're not able to sustain that growth of all those people who have that right to tap into it? Is that, am I missing something? Is that not where they would incur those additional costs to upgrade their entire system to account for all that increased capacity?
Chairman Vaughn.
If you were dealing with sizable tracts that could develop that much waste stream, yes. But what we have here is, if you'll notice in the bill as well, it says that if a landowner believes that the sewer system operator has violated the criteria above, they can submit a complaint to TBOR, Tennessee Board of Utility Regulation. And so if you apply for connection to that system, then the impetus becomes to you. If I'm, in this case, let's say that I'm City of Memphis Public Works, if I say that we don't have capacity for that waste stream that you're proposing to put in there, if you come before TBOR, which is made up of industry experts, then they will either concur or they will side on the side of the landowner. What we're doing here is we're codifying the way the system already works, but this is putting a little bit more teeth to it.
Chairman Clemens.
Thank you, Mr. Speaker.
Representative Butler.
Thank you, Mr. Speaker. I move previous question.
Previous question been called. Is there objection? Seeing none, we're voting. All those in favor of Senate Bill 1138, vote aye when the bell rings. Those opposed, vote no. As every member voted, does any member wish to change their vote? So pick your eye. Ms. Clerk, please take the vote.
Aye, 71, 22 nays.
Senate Bill 1138, having received a constitutional majority, I hereby declare passed by objection. Most reconsider is tabled. Next bill, Ms. Clerk.
Item 53, House Bill 667 by Chairman Terry, relative to waste management. Mr. Speaker, the Senate bill is on the desk.
Chairman Terry, you're recognized.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 438.
Chairman Terry moves substitute and conform Senate Bill 438, probably seconded without objection. So ordered. Chairman Terry.
Thank you, Mr. Speaker. I move passage of Senate Bill 438 on third and final consideration.
Chairman Terry moves passage of Senate Bill 438 on third and final consideration, probably seconded. Ms. Clerk, call up First Amendment.
House Agriculture and Natural Resources Committee Amendment Number 1.
Chairman Todd, you're recognized.
Thank you, Mr. Speaker. Move to the heel of the amendments.
Without objection, roll to the hill. Next amendment, Ms. Clerk.
Amendment 2 by Chairman Todd. Mr. Speaker, it was timely filed.
Chairman Todd, you're recognized.
Move to adopt.
Chairman Todd moves adoption of amendment number 2, probably seconded. Any discussion on the amendment? Seeing none, any objection to the question? Seeing none, we're on the board. All those in favor of adopting amendment number 2, vote aye when the bell rings. Those opposed, vote no. Ms. Clerk, please take the vote.
Ayes 94, no nays.
Amendment number 2 is adopted. Next amendment, Ms. Clerk.
Mr. Speaker, that brings the body back to House Ag and Natural Resources Committee Amendment number 1.
Chairman Todd, you recognize.
Thank you, Mr. Speaker. Move to withdraw.
Without objection, amendment number 1 withdrawn. Next amendment, Ms. Clerk. Mr. Clerk.
No further amendments, Mr. Speaker.
Chairman Terry, you recognize.
Thank you, Mr. Speaker. And what this bill does, it creates an advisory task force on the disposition of solid waste. I renew my motion.
Chairman Terry renews his motion. Any discussion on the bill? Seeing none, any objection to the question? Seeing none, we're voting. All those in favor of Senate Bill 438 as amended, vote aye when the bell rings. Those opposed, vote no. As every member voted, does any member wish to change their vote? Carry aye. Ms. Clark, please take the vote.
Ayes 94, no nays.
Senate Bill 438 having received a constitutional majority, I hereby declare passed without objection. Motion to reconsider is tabled. Call up next bill, Ms. Clark.
Item 54, House Bill 717 by Representative Jones of Unicoi, relative to relief for caregivers of individuals with Alzheimer's disease or related dementia.
Representative Jones, you're recognized.
Thank you, Mr. Speaker. I move passage of HB 0717 on third and final consideration.
Representative Jones moves passage by seconded. Ms. Clark, called First Amendment.
House Finance, Ways and Means Committee Amendment number 1.
Chairman Hicks, you're recognized.
Thank you, Mr. Speaker. Move to adopt and defer to the sponsor for further explanation.
Chairman Hicks moves adoption of committee amendment number 1, probably seconded. Any discussion on the amendment? Seeing none. All those in favor of committee amendment number 1 say aye. Aye. All those opposed say no. The ayes have it. You adopt. Next amendment, Ms. Clerk.
No further amendments, Mr. Speaker.
Representative Jones, you're recognized.
Thank you, Mr. Speaker. The amendment rewrites the bill, and what this does is to extend the Alzheimer's and Dementia Respite Care Pilot Program. With that, I renew my motion.
Representative Jones renews her motion. Any discussion on the bill? Representative Chairman Williams.
Thank you, Mr. Speaker. Representative Jones, excellent bill. I know this is not the path you originally started on, but I just want to encourage you. This is a great bill. As this body remembers, 2 years ago, we passed the Colonel Bowden Act as it relates to hospice care or respite care for those family members who are providing health care for their loved ones who were suffering with Alzheimer's. What this bill does, members, is it extends that pilot program another year because there were additional funds. They are yet to do that. I know your original bill had to do with other services and support for those who are caring for their loved ones. We look forward to working on that next year, but I think this is extremely valuable because even though Alzheimer's is very difficult for the person who has it, the largest weight or burden carried in regards to Alzheimer's is actually the family members who are caring for them. And as you and I have discussed, my grandmother passed away from Alzheimer's. And so I'm very passionate about this subject. Appreciate your advocacy for these folks and their families, and look forward to supporting your bill. Thank you.
Thank you, Representative Jones.
Thank you, Chairman Williams. It was an honor to be able to extend your program, so thank you for moving forward with that. With that, I renew my motion.
Representative Pearson.
Thank you so much, Speaker. And sponsor, how does this program or fund work?
Representative Jones.
This is a pilot program, and it just merely is extending what was already in operation. It was a respite care pilot program for Alzheimer's and dementia.
Representative Pearson.
Sorry. How does it work? So I understand there's a fund, but how does it work? How do disbursements work? Maybe Chairman Williams can help out. You gotta cover your mouth, Paul. Come up, bud. That's getting ridiculous.
Chairman Williams, you're recognized.
Thank you, Representative Pearson, for the question. What this bill does is allows, through Department of Aging and Disability, our ability to be able to fund a reimbursement to families through our DDs across the state for the services that they're able to provide at home. So it's providing a respite for those families. Like in the instance of my grandmother, my aunt took care of her. And so the cost of doing that is much less to provide respite care services for a few hours for someone in order to come in and help with their loved one, so that my aunt, who is, when somebody has Alzheimer's, It's just 24-hour a day thing. This will allow them to pay an individual to come into the home so they can go grocery shop and pay their bills, pick up the laundry, and do things like that without leaving that loved one at home. It just gives them an opportunity for reimbursement for those hours.
Representative Pearson.
Is this qualified as income for the caregiver?
Chairman Williams.
No, sir.
Representative Pearson.
So what do they, I'm sorry, so if you're not working, but the work that you're doing is caring for this loved one, you're saying you're being reimbursed for that time, which is very similar to wages. So what is it classified as?
Chairman Williams.
Thank you. Maybe I better say it this way. There's a third party that comes into the home to provide those respite care services. So in the instance that I gave you, as my aunt would leave, then Representative Jones may come and stay at the house for 3 or 4 hours with my grandmother, and that the cost associated with that is reimbursed through this pilot program.
Representative Pearson.
So when you hire a third party, the cost of paying for that third party, you get that money back.
Chairman Williams.
Yes, sir.
Representative Pearson.
Thank you.
Representative Powers.
Thank you, Mr. Speaker. Move previous question.
Previous question been called. Is there objection? Seeing none, we're voting. All those in favor of House Bill 717 as amended, vote aye when the bell rings. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Ms. Clerk, please take the vote.
Ayes 94, no nays.
House Bill 717 having received a constitutional majority, I hereby declare passed without objection. Most reconsider table. Ms. Clerk, call up next bill.
Item 55, House Bill 726 by Chairman Hicks, relative to taxation.
Chairman Hicks, you're recognized.
Thank you, Mr. Speaker. I move passage of House Bill 726 on third and final consideration.
Chairman Hicks moves passage, probably seconded. Ms. Clerk, call up First Amendment.
House State and Local Government Committee Amendment Number 1.
Chairman Crawford, you are recognized.
Thank you, Mr. Speaker. This amendment rewrites the bill. I move to adopt and defer to the sponsor for explanation.
Chairman Crawford moves adoption. Committee Amendment Number 1, probably seconded. Any discussion on the amendment? Seeing none. All those in favor of Amendment Number 1 say aye. Aye. All those opposed say no. The ayes have it. You adopted. Next amendment, Ms. Clerk.
No further amendments, Mr. Speaker.
Chairman Hicks, you're recognized.
Thank you, Mr. Speaker. Members, House Bill 726 extends the deadline as established by Public Chapter 6 of the first extraordinary session of 2025, by which a property assessor must determine that property was destroyed or damaged by Hurricane Helene from January 28, 2025 to April the 15th, 2025, in order for the property owner to qualify for a relief, again, provided by the state. And with that, I renew my motion.
Chairman Hicks renews the motion. Any discussion on the bill? Seeing none, any objection to the question? Seeing none. All those in favor of House Bill 726 as amended, vote aye when the bell rings. Those opposed, vote no. As every member voted, does any member wish to change their vote? Ms. Clerk, please take the vote.
Ayes 91, no nays.
House Bill 726 having received the constitutional majority, I hereby declare passed without objection. Most reconsider table. Call up next bill, Ms. Clerk.
Item 56, House Bill 761 by Chair Lady Littleton, relative to the Protect Tennessee Minors Act. Mr. Speaker, the Senate bill is on the desk.
Chair Lady Littleton, you're recognized.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 448.
Chair Lady Littleton moves substitute and conform Senate Bill 448 without objection. So ordered. Chair Lady Littleton.
Thank you, Mr. Speaker. I move passage of Senate Bill 448 on third and final consideration.
Chair Lady Littleton moves passage of Senate Bill 448 on third and final consideration. Probably seconded. Ms. Clerk, call up First Amendment.
No amendments, Mr. Speaker.
Chair Lady Littleton, you are recognized.
Thank you, Mr. Speaker. This bill removes the definition of content harmful to minors from the Protect Tennessee Minors Act. With that, Mr. Speaker, I renew my motion.
Chair Lady Littleton renews her motion. Any discussion on the bill? Representative Burkhart, you're recognized. Representative Burkhart, you're recognized.
Thank you, Mr. Speaker. I move previous question.
Previous question been called. Is there objection? Seeing none, we're voting. All those in favor of Senate Bill 448, vote aye when the bell rings. Those opposed, vote no. As every member voted, does any member wish to change their vote? Ms. Clerk, please take the vote.
Ayes 80, 6 nays, 2 present not voting.
Senate Bill 448 having received constitutional majority, I hereby declare it passed without objection. Most reconsider table. Call up next bill, Ms. Clerk.
Item 57, House Bill 773 by Representative Powers, relative to legal notices.
Chairman Powers, you're recognized.
Thank you, Mr. Speaker. I move passage of House Bill 773 on third and final consideration.
Chairman Powers moves passage, probably seconded. Ms. Clerk, call up First Amendment.
House, State, and Local Government Committee Amendment Number 1.
Chairman Crawford, you're recognized.
Thank you, Mr. Speaker. This amendment rewrites the bill. I move to adopt.
Chairman Crawford moves adoption of Amendment Number 1, probably seconded. Any discussion on the amendment? Seeing none, all those in favor of Amendment Number 1 say aye. Aye. All those opposed say no. The ayes have it. We adopt the next amendment, Ms. Clerk.
Amendment Number 2 by Representative Powers. Mr. Speaker, it was not timely filed.
Chairman Powers, you're recognized.
Thank you, Mr. Speaker. This is simply a request from the Secretary of State's office to exclude sample ballots from this bill. So I move to adopt.
Consideration.
Consideration, sorry.
Thank you. You've heard the motion, probably seconded. We're voting for consideration of Amendment Number 2. All those in favor of considering Amendment Number 2, vote aye when the bell rings. Those opposed, vote no. As every member voted, does any member wish to change their vote? Ms. Clerk, please take the vote.
Ayes 90, no nays.
In accordance with Rule 60B, having received the necessary two-thirds vote, the motion to consider Amendment Number 2 prevails. Chairman Powers, you're recognized.
Thank you, Mr. Speaker. House Bill 773 just provides that when legal notices, except for foreclosures and now sample ballots, are required to be published in a newspaper of general circulation, the notice must also be published on another news and information website in the county if one is available. This does not affect our newspapers at all. Let me repeat, does not affect our newspapers at all. It simply adds another layer of transparency for legal notices for the general public. So we're not taking any legal notice away from the newspaper of general circulation. It prohibits legal notices from being published in a news and information website that requires a fee or a subscription for a person to view that website. And with that, Mr. Speaker, I renew my motion. Oh, I'm sorry. Move adoption of Amendment Number 2.
Chairman Powers moves adoption of Amendment Number 2. Proper motion, probably second. Any discussion on the amendment? On the amendment, Representative Hardaway.
Thank you, Speaker. Elaborate on why the Secretary of State does not want sample ballots included in this.
Chairman Powers.
Okay, thank you. Yes, sample ballots are very long, very detailed, and all we're trying to do is make sure that public notices of things that a municipality or something may have information on be published on an information website, because they come up, and a lot of counties only have one newspaper per county. So this is something that will give some transparency and have another option on there. Sample ballots were not intended to be on there. They'll still be in the newspaper of circulation as they are now.
Representative Hardaway. Very good. All right. We're on Amendment Number 2. Any objections to the question? Seeing none, we're voting. All those in favor of adopting Amendment Number 2, vote aye when the bell rings. Those opposed, vote no. As every member voted, does any member wish to change their vote? Ms. Clerk, please take the vote.
Ayes 90, no nays, one present not voting.
Amendment Number 2 is adopted. Next amendment, Ms. Clerk.
No further amendments, Mr. Speaker.
Chairman Powers, you're recognized.
Thank you, Mr. Speaker. This simply requires any news and information website to be published to be a separate and distinct website away from the newspaper of general circulation that is owned by an entity other than the newspaper of general circulation. And with that, I renew my motion.
Chairman Powers renews the motion. Any discussion on the bill? Seeing none, any objection to the question? Seeing none, we're voting. All those in favor of House Bill 773 as amended, vote aye when the bell rings. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Ms. Clerk, please take the vote.
Ayes 84, 2 nays, 5 present not voting.
House Bill 773 and received constitutional majority. Everybody declare passed without objection. Motion to reconsider is tabled. Next bill, Ms. Clerk.
Item 59, House Bill 787 by Chair Lady Moody, relative to criminal justice. Mr. Speaker, the Senate bill is on the desk.
Chair Lady Moody, you are recognized.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 932.
Chair Lady Moody moves to substitute conform Senate Bill 932, probably seconded without objection. So ordered. Chair Lady Moody.
Thank you, Mr. Speaker. I move passage of Senate Bill 0932 on third and final consideration.
Chair Lee Moody moves passage of Senate Bill 932 on third and final consideration. Probably seconded. Ms. Clerk, call up first amendment.
House Judiciary Committee Amendment Number 1. Mr. Speaker, it's the same as Senate Amendment Number 1.
Chairman Farmer, you're recognized.
Thank you, Mr. Speaker. Move to withdraw.
Without objection, amendment number 1 withdrawn. Next amendment, Ms. Clerk.
No further amendments, Mr. Speaker.
Chair Lee Moody, you're recognized.
Thank you, Mr. Speaker. And members, this simply is a request from my General Sessions Judge in Tipton County to do a study that he has named the Distance to Drive program. And this will set up the committee for us to look into the issues with DUIs and the payment of the fines. And with that, I renew my motion.
Chair Lee Moody renews her motion. Any discussion on the bill? Seeing none, any objection to the question? Seeing none, we're voting. All those in favor of Senate Bill 932, vote aye when the bell rings. Those opposed, vote no. Has every member voted? Is any member which change their vote? Ms. Clerk, please take the vote.
Ayes 90, no nays.
Senate Bill 932 and received constitutional majority. I hereby declare passed without objection. The most reconsidered table. Call up next bill, Ms. Clerk.
Item 60, House Bill 802 by Chairman Grills, relative to state employees. Mr. Speaker, the Senate bill is on the desk.
Chairman Grills, you're recognized.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 0411.
Chairman Grills moves substitute and conform Senate Bill 411 without objection. So ordered. Chairman Grills.
Thank you, Mr. Speaker. I move passage of Senate Bill 0411 on third and final consideration.
Chairman Grills moves passage of Senate Bill 411 on third and final consideration. By second, Ms. Clerk, call up first amendment.
No amendments filed, Mr. Speaker.
Chairman Grills, you're recognized.
Thank you, Mr. Speaker. This bill provides liability coverage for conservation districts. This will allow them to use the surplus vehicles or surplus federal vehicles that they have the permission to use. With that, I renew my motion.
Chairman Grills renews his motion. Any discussion on the bill? Seeing none, were any objection to the question? Seeing none. All those in favor of Senate Bill 411 vote aye when the bell rings. Those opposed vote no. Has every member voted? Does any member wish to change their vote? Ms. Clerk, please take the vote.
Ayes 89, no nays.
Senate Bill 411 having received a constitutional majority, everybody declare passed without objection. The most reconsidered table. Next bill, Ms. Clerk.
Item 61, House Bill 842 by Chairman Crawford, relative to taxes on transfers of realty. Mr. Speaker, the Senate bill is on the desk.
Chairman Crawford, you're recognized.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 843.
Chairman Crawford moves substitute and conform Senate Bill 843. Proper second without objection. So ordered. Chairman Crawford.
Thank you, Mr. Speaker. I move passage of Senate Bill 843 on third and final consideration.
Chairman Crawford moves passage of Senate Bill 843 on third and final consideration. By second, Ms. Clerk, call up first amendment.
House State and Local Government Committee Amendment Number 1. Mr. Speaker, it's the same as Senate Amendment Number 2.
Vice Chairman Wright, you're recognized.
Thank you, Mr. Speaker. Move same as Senate Amendment Number 2, move to withdraw.
Without objection, amendment number 1 withdrawn. Next amendment, Ms. Clerk.
House State and Local Government Committee Amendment Number 2. Mr. Speaker, it's the same as Senate Amendment Number 1.
Vice Chairman Wright, you're recognized.
Thank you, Mr. Speaker. Same as Senate Amendment Number 1, move to withdraw.
Without objection, amendment number 2 withdrawn. Next amendment, Ms. Clerk.
No further amendments, Mr. Speaker.
Chairman Crawford, you're recognized.
Thank you, Mr. Speaker. This is the TWRA bill. What we are doing here is giving some leeway that the TWRA can spend down some of the wetland acquisition funds on capital projects. I renew my motion.
Chairman Crawford renews the motion. Any discussion on the bill? Seeing none, any objection to the question? Seeing none, we're voting. All those in favor of Senate Bill 843 vote aye when the bell rings. Those opposed vote no. Has every member voted? Does any member wish to change their vote? Ms. Clerk, please take the vote.
Ayes 81, 3 nays, 5 present, not voting.
Senate Bill 843 has received a constitutional majority. Hereby declare passed without objection. Most reconsidered table. Leader Cochran, for what purpose?
Thank you, Mr. Speaker. I move that we take up item number 66, HB 1299 at this time.
Without objection, so ordered. Ms. Clerk, call up the bill. Chairman Faison, what purpose?
Make a motion to roll 10 spaces. Just kidding.
That's out of order. so far out of order. Ms. Clerk.
Item 66, House Bill 1299 by Leader Lambert and others relative to the unauthorized use of deepfake or actual likeness. Mr. Speaker, the Senate bill is on the desk.
Leader Lamberth, you recognize.
Thank you, Mr. Speaker. Move to substitute and conform to Senate Bill 1346.
Leader Lamberth moves substitute and conform Senate Bill 1346, probably second without objection. So ordered. Leader Lamberth.
Thank you, Mr. Speaker. Move passage of Senate Bill 1346 on third and final consideration.
Leader Lamberth moves passage of Senate Bill 1346 on third and final consideration. Properly second. Ms. Clerk, call for First Amendment.
House Judiciary Committee Amendment Number 1. Mr. Speaker, it's the same as Senate Amendment Number 1.
Chairman Farmer, you recognize.
Thank you, Mr. Speaker. Move to withdraw.
Without objection, amendment number 1 withdrawn. Next amendment, Ms. Clerk.
No further amendments, Mr. Speaker.
Leader Lamberth, you recognize.
Thank you, Mr. Speaker. Ladies and gentlemen, this bill highlights how AI can be a phenomenal tool, but it can be a phenomenal weapon against those that are completely innocent in this world, but happen to come into our lives through our TV screens and the internet. Miss Bree Smith is with us right up here with her family, and she was a victim where some horrible human being took her face and grafted her face onto a body that was not hers, and then tried to parade that out on the internet specifically just to try to embarrass her and use her in a way that she never would have authorized her image to be utilized. Several of us have carried bills like this, and I stand here with a couple of our colleagues that this is important to, and we hope that you will support this bill as well, because in the AI era, ladies like Miss Bree should never have to worry about going online, or her husband or her family going online and seeing an image that somebody else has created that doesn't anywhere near reflect who the phenomenal person that she is. And with that, Mr. Speaker, I renew my motion.
Leader Lamberth renews his motion. Any discussion on the bill? Seeing none, any objection to the question? Seeing none, we're voting. All those in favor of Senate Bill 1346, vote aye when the bell rings. Those opposed, vote no. Has every member voted? Does any member wish to change your vote? Ms. Clerk, please take the vote.
Ayes 94, no nays.
Senate Bill 1346, having received a constitutional majority, I hereby declare it passed. Without objection, most read series table. Call up next bill, Ms. Clerk.
Item 62, House Bill 930 by Chairman White, relative to the Homebuyers Revolving Loan Program. Mr. Speaker, the Senate bill is on the desk.
Chairman White, you recognize.
Thank you, Mr. Speaker. Move to substitute conform to Senate Bill 857.
Chairman White moves to substitute and conform Senate Bill 857 without objection. So ordered. Chairman White.
Thank you, Mr. Speaker. I move passage of Senate Bill 857 on third and final consideration.
Chairman White moves passage of Senate Bill 857 on third and final consideration. By second, Ms. Clerk, call up First Amendment.
No amendments, Mr. Speaker.
Chairman White, you're recognized.
Thank you, Mr. Speaker. Members, this bill was brought to me, and what it is, in 1986, the Home Buyers Revolving Loan Fund was established. It was created to support the down payment assistance to our low and moderate income families. Well, in the past 40 years, because of the 1980s era terms and limits that made the program less attractive today, because of lower interest rates and moderate rates periods of like today, this legislation just updates that revolving loan fund in our state code to allow the 3.1 million that is set in the loan fund to be more accessible, to continue to serve the low and moderate income families, as well as open the program up to builders that support the construction of affordable housing. And it's still under the management of the Tennessee Department of Tennessee Housing Development. With that, I renew my motion.
Chairman White renews his motion. Any discussion on the bill? Representative Shaw.
Thank you, Mr. Speaker. Call for the question.
First question been called. Any objection? Seeing none, we're voting. All those in favor of Senate Bill 857, vote aye when the bell rings. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Darby, aye. Ms. Clerk, please take the vote.
Ayes 91, one nay, one present not voting.
Senate Bill 857, having received constitutional majority, I hereby declare passed without objection. Most read series table. Call up next bill, Ms. Clerk.
Item 63, House Bill 958 by Representative Slater, relative to education. Mr. Speaker, the Senate bill is on the desk.
Representative Slater, you recognize.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 950.
Representative Slater moves to substitute and conform to Senate Bill 950, probably seconded without objection. So ordered. Leader Lambert, for what purpose?
Thank you, Mr. Speaker, and I had spoken with the sponsor on this, but move to roll this 10 spaces.
All right. Without objection, so ordered. Call up next bill, Ms. Clerk.
Item 64, House Bill 964 by Representative Hawk, relative to school safety. Mr. Speaker, the Senate bill is on the desk.
Chairman Hawk, you're recognized.
Thank you, Mr. Speaker. Move passage of, substitute conform to the Senate bill.
Chairman Hawk moves substitute conform to Senate Bill 899 without objection, so ordered. Chairman Hawk.
Thank you, Mr. Speaker. Move passage of Senate Bill 899 on third and final consideration.
Chairman Hawk moves passage of Senate Bill 899 on third and final consideration. Properly seconded. Ms. Clerk, call the First Amendment.
No amendments, Mr. Speaker.
Chairman Hawk, you're recognized.
Thank you, Mr. Speaker. This is legislation brought to us as a housekeeping bill by our architects in coordination with the Department of Education and Department of Safety, as well as the State Fire Marshal's Office. The purpose is to allow for consistent, efficient implementation of the school safety bill we passed in 2023 related to school building design requirements. This is only updating terminology for safety glass. With that, I renew my motion.
Chairman Hawk renews motion. Any discussion on the bill? Seeing none, any objection to the question? Seeing none. All those in favor of Senate Bill 899, vote aye when the bell rings. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Ms. Clerk, please take the vote.
Ayes 92, no nays.
Senate Bill 899 having received constitutional majority, I hereby declare passed without objection. The motion for reconsider is tabled. Call up next bill, Ms. Clerk.
Item 65, House Bill 969 by Representative Hawk, relative to transportation.
Chairman Hawk, you're recognized.
Thank you, Mr. Speaker. Move passage of House Bill 969 on third and final consideration.
Chairman Hawk moves passage by seconded. Ms. Clerk, please call it First Amendment.
House Transportation Committee Amendment Number 1.
Chairman Howell, you're recognized.
Thank you, Mr. Speaker. Move to withdraw.
Without objection, Amendment Number 1 withdrawn. Next amendment, Ms. Clerk.
House Finance Ways and Means Committee Amendment Number 1.
Chairman Hicks, you're recognized.
Thank you, Mr. Speaker. Move to adopt.
Chairman Hicks moves adoption of Committee Amendment Number 2. Probably seconded. Any discussion on the amendment? Seeing none. All those in favor of adopting Committee Amendment Number 2, say aye. Aye. All those no, say aye. Ayes have it. It's adopted. Next amendment, Ms. Clerk.
No further amendments, Mr. Speaker.
Chairman Hawk, you're recognized.
Thank you, Mr. Speaker. This is a bill that we've been working on for a little while now that is in the budget and recognizes $80 million of recurring revenue to go toward our highway fund. We've been looking at this for quite some time. And what it does is takes the sales tax from tires sold in the state of Tennessee and dedicates those solely toward the transportation fund. With that explanation, I renew my motion.
Chairman Hawk renews his motion. Any discussion on the bill? Leader Lambert.
Thank you, Mr. Speaker. Representative, you've been working on this idea for a long time. I know $80 million is a lot of money to go to the road fund. If you had a goal of the amount that you would try to shift into the road fund each year, what would it be?
Chairman Hawk.
Thank you. If I could use the past 3 years of budgets as an explanation or to answer that question, the Transportation Modernization Act, we used $3 billion of non-recurring funds, general fund dollars to go toward transportation. So $3 billion 3 years ago, actually, now as we're looking at this next budget. This budget we passed last week, we put an additional $1 billion of non-recurring funds toward transportation. I'll take that $4 billion we put non-recurring divided by 3 and ask for even a little bit less. Let's put $1 billion of recurring dollars to go toward transportation funding in perpetuity, so we can catch up on the $38 billion of backlog we have on our state roads and bridges to bring us up to where we need to be. I will bring legislation back in 2026 that will call for us to do that. The initial language of this piece of legislation called for the sales taxes collected on motor vehicle sales, which was roughly going to hit that $1 billion recurring. I'll bring back that next year and try again for a 9th year. Thank you.
Thank you. Representative Warner, you're recognized.
Thank you, Mr. Speaker, and thank you, sponsor. I think I support your bill, but I just want to be clear here. We are not creating a new tax. Is that correct?
Chairman Hawk.
No way, shape, or form are we creating a new tax. It's existing revenues that are currently going to general fund, which again, as I'll reiterate, we've already been allocating on a non-recurring basis to transportation. We're going to put these dollars on a recurring basis toward transportation going forward.
Representative Warner.
Thank you for your work on the bill, sir. Thank you.
Any further discussion? Chairman Clemens.
Thank you, Mr. Speaker. I'd be remiss if I didn't point out the fact that we like to brag about how we're a low debt state or a no debt state. And we talk about pay as you go, but we refuse for some reason to still bond infrastructure projects. Even though last week we just passed bonding for higher education projects, everything else. We are $45 billion behind in infrastructure projects. We're never going to catch up by taking money out of the general fund, $1 billion at a time, $2 billion at a time, and putting it in to the state highway fund. It's just not going to happen, guys. Road projects and all the infrastructure projects in your district are never going to happen unless we modernize the way we fund transportation infrastructure. It's simple as that. Thank you, Mr. Speaker.
Chairman Hawk.
I disagree with you completely.
Chairman Clemens.
Mr. Speaker, I appreciate that. I appreciate that you disagree with me, but facts are facts. The money don't add up. And we can be as stubborn as we want to be when it comes to pay as you go, but we will never address the transportation problems plaguing this state, namely my district, one of the fastest growing corridors in the entire country. I-24 is a disaster. It will never be fixed as long as we refuse to modernize the way we fund these projects. Toll lanes aren't going to fix it. It's going to exacerbate the problem. Folks in Rutherford County, trust me, they want it fixed just as badly as I do. It is never going to happen until we said we'd never break the seal between our bifurcated budget and start stealing money from the general fund, putting in the highway fund a couple of cents at a time. It's just not going to happen, folks. We've got to wake up. We bond everything now except for road infrastructure. Give me a break. Thank you, Mr. Speaker.
Chairman Hawk.
Thank you, Mr. Speaker. I was here when we took money from the transportation fund and put it to the general fund. So I've seen it go from that direction to the general fund. We're trying to get those dollars back, and we're trying to get those on a recurring basis. I feel confident if we get recurring revenue going toward the transportation fund, we will catch up and we will do what our citizens expect. I renew my motion.
Representative Travis.
Thank you, Mr. Speaker. Move previous question.
Previous question's been called. No objection. We're voting. All those in favor of House Bill 969 as amended, vote aye when the bell rings. Those opposed, vote no. Has everyone voted? Does anyone wish to change their vote? All right, we're good, y'all. I appreciate the banter. Ms. Clerk, please take the vote.
Ayes 89, no nays.
House Bill 969 having received constitutional majority, everybody declare passed without objection. The motion to reconsider is tabled. Leader Camp, for what purpose?
Thank you, Mr. Speaker. Mr. Speaker, I move that we take up item 71 on the calendar.
Without objection, so ordered. Ms. Clerk.
Item 71, House Bill 1378 by Representative Harris, relative to examinations for driver's licenses and intermediate driver's license. Mr. Speaker, the Senate bill is on the desk.
Representative Harris, you're recognized. Representative Harris.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 1420.
Representative Harris moves to substitute and conform Senate Bill 1420 without objection, so ordered. Representative Harris.
Thank you, Mr. Speaker. I move passage of Senate Bill 1420 on third and final consideration.
Representative Harris moves passage of Senate Bill 1420 on third and final consideration. Probably seconded. Ms. Clerk, call for First Amendment.
No amendments, Mr. Speaker.
Representative Harris, you're recognized.
Thank you, Mr. Speaker. With the growing bicycle population and bike lanes in Tennessee, House Bill 1378 would require a written examination administered to applicants for a driver's license and the driver's license manual to both include questions and information concerning hand signals used by bicycle operators to communicate hand signs like turning, slowing, and stopping. And with that, Mr. Speaker, I renew my motion.
Representative Harris renews his motion. Any discussion on the bill? Seeing none, any objections to the question? Seeing none, all those in favor of Senate Bill 1420 vote aye when the bell rings. Those opposed vote no. As every member vote, does any member wish to change their vote? Ms. Clerk, please take the vote.
Ayes 93, no nays.
Senate Bill 1420 on received constitutional majority. Everybody declare passed by objection. Most reconsider stable. Call up next bill, Ms. Clerk.
That brings the body back to item 67, House Bill 1302 by Representative Jones of Unicoi and others relative to the inspection of food derived from animals. Mr. Speaker, the Senate bill is on the desk.
Representative Jones, you're recognized.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 1265.
Representative Jones moves substitute and conform Senate Bill 1265. Properly seconded without objection. So ordered. Representative Jones.
Thank you, Mr. Speaker. I move passage of Senate Bill 1265 on third and final consideration.
Representative Jones moves passage of Senate Bill 1265 on third and final consideration. Properly seconded. Ms. Clerk, call up First Amendment.
House Agriculture and Natural Resources Committee Amendment Number 1. Mr. Speaker, it's the same as Senate Amendment Number 1.
Chairman Todd, you're recognized.
Thank you, Mr. Speaker. Same as Senate amendment. Move to withdraw.
Without objection, amendment number 1 withdrawn. Next amendment, Ms. Clerk.
No further amendments, Mr. Speaker.
Representative Jones, you're recognized.
Thank you, Mr. Speaker. What this bill does is in 2023, Representative Reedy passed the Tennessee Meat and Poultry Act bill. This bill provides a vehicle to set up a state meat inspection that will help us align with the Federal Food Safety Inspection Act. With that, I renew my motion.
Representative Jones renews her motion. Any discussion on the bill? Seeing none, any objection to the question? Seeing none, all those in favor of Senate Bill 1265 vote aye when the bell rings. Those opposed vote no. As every member voted, does any member wish to change their vote? Ms. Clerk, please take the vote.
Ayes 92, no nays.
Senate Bill 1265 having received constitutional majority, everybody declare passed by objection. Most reconsider stable. Call up next bill, Ms. Clerk.
Item 68, House Bill 1307 by Chair Lady Moody and others relative to priority schools. Mr. Speaker, the Senate bill is on the desk.
Chair Lady Moody, you're recognized.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 1273.
Chair Lady Moody moves substitute conform Senate Bill 1273, probably seconded without objection. So ordered. Chair Lady Moody.
Thank you, Mr. Speaker. I move passage of Senate Bill 1273 on third and final consideration.
Chair Lady Moody moves passage of Senate Bill 1273 on third and final consideration, probably seconded. Ms. Clerk, call up First Amendment.
House Education Committee Amendment Number 1. Mr. Speaker, it's the same as Senate Amendment Number 2.
Chairman White, you're recognized.
Thank you, Mr. Speaker. Same as the Senate amendment, so I move to withdraw.
Without objection, amendment number 1 withdrawn. Next amendment, Ms. Clerk.
No further amendments, Mr. Speaker.
Chair Lady Moody, you're recognized.
Thank you, Mr. Speaker. This bill is simply the sunset for the ASD, and they have until 2026 to that will be their last year. With that, I renew my motion.
Chair Lady Moody renews the motion. Any discussion on the bill? Representative Parkinson.
Thank you, Mr. Speaker. I won't mention bill jacking in my comments, but I do want to say thank God. $2 billion later, $2 billion later, we finally end this catastrophe of an experiment in education served on the backs of our communities. This was such a grand scheme of we're going to take the bottom 5% of schools and move them to the top 25% in 5 years. And then there was scandal after scandal after scandal. The Tennessee Achievement School District was the worst education experiment ever attempted by the state of Tennessee. Every single school, with the exception of maybe a few out of the 41 schools that were taken into the Achievement School District to turn around our lowest performing schools, performed worse than our lowest performing schools. And imagine this, If our lowest performing school is on the floor of this chamber, then the Tennessee Achievement School District performed on the governor's floor. So I needed y'all to see that visually. Just when we thought the schools couldn't perform any worse because they're at the bottom of the 5%, the Tennessee Achievement School District came and proved us wrong. We can perform worse than the worst school in the entire state. And they did just that over and over and over and over. And $2 billion of your tax dollars went to support that for the last 15 years almost. $2 billion. Madam Sponsor, I venture to say that if you invested 2,000 of your own personal dollars into a scheme, after the first year, you would not invest anymore. But we invested $100 million per year since 2011 of taxpayer dollars and protected it. But not a single person in here would do that with their own money. Not a single person in here would do that with their own money. Now, I'm glad that this bill is here, Madam Sponsor, but I do understand that we're sunsetting the Achievement School District, but we're remixing it under the auspices of the Charter Commission. That's your new Achievement School District. And we're going to tell Shelby County, under this bill that's possibly coming, that this board has the ability to convert all your schools to a charter, and you can't say no. So it's just remixed. Well, I thank you for, ending this on this sheet of paper, but it's not really ending. We're going to keep on and keep on and keep on until every one of your districts are converted to either chartered or vouchered districts. You better believe that. So as y'all are thinking about these votes and as y'all are thinking about the new versions of the schemes, keep that in mind. Remember, they only said it was going to be charters for Shelby and Davidson. Then all of a sudden they opened the floodgates. And that's what's coming. The goal is to privatize the entire state of Tennessee's education. They're starting, we were the test dummies. And guess what? It failed. And now they're going to come back and say, hey, open the floodgates of.
All right. Thank you. Yeah. I have to go back and watch a video. I don't remember what that was. Chair Lady Moody, you recognize.
Thank you, Mr. Speaker. And members, this legislation today is not about charter schools, but it is about providing more localized options for school turnaround. Conversion to a charter school is just one of many options in this legislation, and it must be chosen by the school district.
Thank you. Representative Hardaway.
Thank you, Speaker. Chair Lady, I'm concerned about the unfunded mandate aspect of this. The fiscal note says not significant, but I'm trying to figure out who's going to pay for the tier 1, tier 2, tier 3 intervention process.
Chairlady Moody, you recognize. Chairlady Moody.
Yes, yes, sir. I'm sorry. It is not significant. The fiscal note is not significant.
Representative Hardaway.
Okay, I would suggest that we do a little more investigation on that, unless perhaps Leader Lambert has some thoughts on that.
Leader Lambert.
The fiscal note is not significant.
Representative Hardaway.
Thank you, Speaker. I can't wait until we get that not significant bill down in Shelby County for Tier 1, Tier 2, Tier 3. So I would suggest that we do more investigation on what the costs are going to be for these conversions. Thank you.
Thank you. Speaker Pro Tem Marsh.
Thank you, Mr. Speaker. I've called previous question.
Previous question been called. Is there objection? All those in favor of previous question vote aye when the bell rings. Those opposed vote no. Has every member voted? Does any member wish to change their vote? Ms. Clerk, please take the vote.
Aye 69, 21 nays.
Previous question prevails. We're voting. All those in favor of Senate Bill 1273 vote aye when the bell rings. Those opposed vote no. Has every member voted? Does any member wish to change their vote? Ms. Clerk, please take the vote.
Aye 75, 15 nays, 2 present not voting.
Senate Bill 1273 having received a constitutional majority, hereby declare passed without objection. The motion to reconsider is tabled. Call next bill, Ms. Clerk.
Item 69, House Bill 1326 by Chairman Vaughn and others relative to planning. Mr. Speaker, the Senate bill is on the desk.
Chairman Vaughn, you're recognized.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 1313.
Chairman Vaughn moves substitute and conform to Senate Bill 1313 without objection. So ordered. Chairman Vaughn.
Thank you, Mr. Speaker. I now move passage of Senate Bill 1313 on its third and final consideration.
Chairman Vaughn moves passage of Senate Bill 1313 on third and final consideration. Properly second. Ms. Clerk, call up First Amendment.
No amendments, Mr. Speaker.
Chairman Vaughn, you're recognized.
Thank you, Mr. Speaker. I'm honored to hopefully present the last bill of today. It's a fine piece of legislation. It does two things. Number one is that it builds on the presumption that a application in front of a land planning body controlled by a local government subdivision is considered vested from the time, the rights associated with that are vested from the time of submission. But that submission has to be a complete application as determined by the local subdivision of government. The other is actually an effort to streamline approvals. It allows, and it's only permissive, but it allows local municipal bodies to adopt an administrative approval for conditional use permits. Conditional use permits traditionally have been issued by Board of Zoning Appeals. This sets up an opportunity for them and for them to be done administratively. And with that, Mr. Speaker, I call the question. No, my motion. I'm calling the question. No, I renew my motion.
Chairman Vaughn renews his motion. Any discussion on the bill? Representative Pearson, you're recognized.
Thank you. You said that this bill is permissive sponsor, so 2/3 of the county commission or our locally elected body would have to approve of this in order for it to go into effect?
Chairman Vaughn.
Yes, sir. They would have to adopt the procedures and give the authorization to their staff in Memphis OPD. They would have to tell OPD, hey, you can approve conditional use permits as long as it meets these requirements that are set forth in the zoning code, and do that administratively, but they do cede that power to them.
Representative Pearson.
Thank you.
All right. Any further discussion? Seeing none. Any objection to the question? Hearing none. All those in favor of Senate Bill 1313 vote aye when the bell rings. Those opposed vote no. Has every member voted? Does any member wish to change their vote? Call up next bill, Ms. Clerk. Take the vote, Ms. Clerk. Sorry, a little fast.
Ayes 76, 16 nays, one present not voting.
Senate Bill 1313, I received constitutional majority, hereby declare passed without objection. The most for each series table. Call up next bill, Ms. Clerk.
Item 70, House Bill 1353 by Chair Lady Littleton, relative to interference with government operations. Mr. Speaker, the Senate bill is on the desk.
Chair Lady Littleton, you're recognized.
Thank you, Mr. Speaker. I move to substitute and conform to House Bill 1399.
Chair Lady Littleton moves substitute and conform Senate Bill 1399, properly seconded without objection. So ordered. Chair Lady Littleton.
Thank you, Mr. Speaker. I move passage of Senate Bill 1399 on third and final consideration.
Chair Lady Littleton moves passage of Senate Bill 1399 on third and final consideration, properly seconded. Ms. Clerk, call up First Amendment.
House Judiciary Committee Amendment Number 1. Mr. Speaker, it's the same as Senate Amendment Number 1.
Chairman Farmer, you're recognized.
Thank you, Mr. Speaker. Move to withdraw.
Without objection, amendment number 1 withdrawn. Next amendment, Ms. Clerk.
No further amendments, Mr. Speaker.
Chair Lady Littleton, you're recognized.
Thank you, Mr. Speaker. This bill as amended clarifies the offense of retaliation for past action and expands the list of individuals involved in the judicial process to include a former judge, a former law enforcement officer, a former district attorney general, a former assistant district attorney general, an employee of the judge, a former clerk, a current or former district public defender, a current or former assistant district public defender, an employee of the district public defender. With that, Mr. Speaker, I renew my motion.
Chair Lady Littleton renews her motion. Any discussion on the bill? Leader Lamberth.
Thank you, Mr. Speaker. And I know we've carried bills like this before, but look, these folks are just doing their jobs, and whether or not they're an assistant district attorney, assistant public defender, work for the court, or even a witness, I mean, we have covered that before. So the penalty should be severe. If you're trying to intimidate anybody that's involved in the criminal justice system, in a trial or not, I mean, it's just a horrible thing to do. So I appreciate you raising the penalty up to where it needs to be. Thank you.
Thank you. Any further discussion? Seeing none, any objections to the question? Seeing none, we're voting. All those in favor of Senate Bill 1399 vote aye when the bell rings. Those opposed vote no. As every member voted, does any member wish to change their vote? Ms. Clerk, please take the vote.
Ayes 92, no nays.
Senate Bill 1399, I received constitutional majority, hereby declare passed without objection. Most for each series table. Call up next bill, Ms. Clerk.
Item 72, House Bill 34 by Representative Gillespie, relative to juvenile records. Mr. Speaker, the Senate bill is on the desk.
Leader Lamberth, you recognize.
Thank you, Speaker. Roll to the heel of today's calendar.
Without objection, roll to the hill of today's calendar. Call up next bill, Ms. Clerk.
Item 73, House Bill 132 by Deputy Speaker Zachary, relative to emergency management powers of the governor.
Deputy Speaker Zachary, you're recognized.
Thank you, Mr. Speaker. Move passage of House Bill 132 on third final consideration.
Deputy Speaker Zachary, Ms. Passes, Bobby seconded. Ms. Clerk, call First Amendment.
House Finance, Ways and Means Committee Amendment Number 1.
Chairman Hicks, you're recognized.
Thank you, Mr. Speaker. Move to adopt, defer to the sponsor for further explanation.
Chairman Hicks moves adoption of Committee Amendment Number 1. Bobby seconded. Any discussion on amendment? Seeing none. All those in favor of Committee Amendment Number 1 say aye, aye. All those opposed say no. The ayes have it. You adopted. Next amendment, Ms. Clerk.
No further amendments, Mr. Speaker.
Deputy Speaker Zachary, you're recognized.
Thank you, Mr. Speaker. Members, as amended, this will allow the legislature to terminate a state of emergency at any time through joint resolution. With that, I renew my motion.
Chairman Zachary renews the motion. Any discussion on the bill? Representative Boyd, you're recognized.
Thank you, Mr. Speaker. I move previous question.
Previous question been called. There's objection. We're on the board. All those in favor of previous question, vote aye when the bell rings. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Ms. Clerk, please take the vote.
Aye 70, 21 nays.
Previous question prevails. We're voting. All those in favor of House Bill 132 as amended, vote aye when the bell rings. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Ms. Clerk, please take the vote.
Aye 69, 22 nays.
House Bill 132 and received a constitutional majority. Everybody declare passed by objection. The motion reconsider is tabled. Leader Lamberth.
Thank you, Mr. Speaker. We've done a lot of good work today, and here in a few moments, I anticipate that we will be taking up the remainder of today's calendar tomorrow. At this juncture, I will move that we take up House Consent Calendar 2.
Proper motion, proper second, without objection. So ordered. Chair Lady Moody, you're recognized.
Thank you, Mr. Speaker. I move passage of the consent calendar number 2 on third and final consideration in keeping with Rule 50.
Chair Lady moves passage of the consent calendar. Probably second. Ms. Clerk, any objections have been filed?
No objections filed.
Anyone seeking recognition on the consent calendar? Seeing none, we're voting. All those in favor of the consent calendar, number 2, vote aye when the bell rings. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Ms. Clerk, please take the vote. Please take the vote.
Ayes 88, 0 nays, 4 present not voting.
Having received the constitutional majority, I declare consent calendar passed by objection. The motion reconsider is tabled. Chairman Doggett, you're recognized.
Really make it dramatic.
Excuse me, kid.
Hang on, Chairman. Next order, Ms. Clark.
Unfinished business.
Chairman Doggett, you're recognized.
Thank you, Mr. Speaker. After consultation with both leaders, I move that the rules be suspended for immediate introduction and consideration of House Joint Resolution 694.
Ms. Clerk, read the caption.
House Joint Resolution 694 by Chairman Doggett, a resolution to honor and congratulate Benjamin and Lauren Neal upon their receipt of the Rural Small Business of the Year Award.
You've heard the caption. Are there any objections? Without objections, the rules are suspended. Chairman Doggett.
Thank you, Mr. Speaker. I move adoption of House Joint Resolution 694.
Chairman Doggett moves adoption of House Joint Resolution 694. Probably seconded. Any objection to the question? Seeing none. All those in favor of House Joint Resolution 694 say aye. Aye. All those opposed say no. The ayes have it. I declare adopted without objection. The motion reconsider is tabled. Leader Lamberth, you're recognized.
Thank you, Mr. Speaker. After consulting with the minority leader and the committee chairman, I move that House Bills 938 and 1358 be heard in the Finance, Ways, and Means Subcommittee this week.
For the motion, any objections? Without objection, so ordered. Next order, Ms. Clerk.
Scheduling and procedural announcements.
Ms. Clerk.
Mr. Speaker, tomorrow's schedule will be as follows. 9 a.m., House Hearing Room 1, Finance Subcommittee. Immediately following will be the Finance Full Committee. Immediately following will be Calendar and Rules, and session will be at 10:30. Those committees will all be in Room 1.
Thank you, Ms. Clerk. Next order.
Roll call.
Ms. Clerk, please take the roll.
91 members present.
Next order, Ms. Clerk.
That completes the regular order, Mr. Speaker.
Thank you, Ms. Clerk. Leader Cochran, you're recognized.
Thank you, Mr. Speaker. I move the House stand in recess until 10:30 a.m. on Tuesday, April 22nd, 2025.
Without objection, the House stands recessed until 10:30 a.m. on Tuesday, April 22nd, 2025.